penalty. So even though the applicants in this case were unsuccessful and the court rejected their claims, the court's decision, I think we can say, has had some form of positive effect. This case was not the only one to deal with the death penalty in relation to narcotics crimes that the court has decided. I said that case was from 2007. There was also one brought in 2015, and the applicant in that case argued that the provisions of the narcotics law penalty should really only be, thank you, that's the perfect slide, should really only be applied to the most serious of cases involving drug kingpins, those who really convince other people to engage in distribution or widespread use of drugs. But unfortunately, in that case, we didn't get to a final decision because the court found that this person had no standing. He himself, as far as I know, not being on trial or being involved in any drug-related crime. So then there are a number of cases where drug convicts essentially tried to use the Constitutional Court to challenge provisions under which they'd been convicted, not in a death penalty case, but we see a number of cases, for example, where defendants say they were mere users or addicts, yet they were charged and convicted under provisions that cover a wide variety of drug offences, allow for the imposition of serious penalties. They say they should have been treated as addicts and kind of dealt with in a rehabilitation way, rather than convicted as, for example, a distributor or a person in possession of a significant amount of drugs would be. So we've got this first case, which is 89/2013, involving Firman Putra. He argued that he was convicted for possessing, just looking after someone else's marijuana. He worked in a Benkel, a motorcycle workshop, and was found in possession of about a dozen bags of marijuana, about 200 grams of cannabis. He was treated as if he was the owner of the marijuana, even though he claimed that the drugs were owned by someone else. He argued that these provisions were discriminatory because they discriminated against him somehow, and the court said this isn't discrimination, these rules apply to everyone, and so it refused to consider the arguments or uphold the arguments in this case. Then we have the case, this is 31/2017, involving a Sutrisno Nugroho, who was convicted by the West Jakarta District Court after being found with a relatively small amount of methamphetamine. He was also found to have tested positive to the drug. He argued rather than being treated as a user of narcotics, he should be treated as a victim of the drug. And he also argued that the wrong provision had been applied to him. He should have been dealt with under what was then Article 127 of the narcotics law, which allows rehabilitation of drug users rather than kind of a strict custodial approach. Then we had a similar case in, this is number 48/2011. It's very similar to the previous case that I just mentioned. There was an applicant who argued he was just a user, but in fact he'd had a more serious provision applied to him. Again, the court rejected that case. And we've got a couple of other cases, 44/2019, involving Mr. Andy, who was convicted of conspiracy to be involved in the selling or receipt of Class 1 narcotics. And he argued that as the person who wasn't a direct perpetrator, he should not be facing the same penalties as a direct perpetrator, but the court says, no, that is not a grounds for constitutional challenge. And the final of these cases was a rather interesting case 86 of 2020, Ardian Aldiano, who essentially argued that Article 111(2) of the narcotics law, which makes or increases the penalty for a drug convict who's involved in growing, looking after, possessing or supplying up to more than 5 trees of a plant-based narcotic. He argued that the definition of tree in the drug law should correspond with the definition of tree in a forestry law. And so he was arguing that he'd actually not been found with any trees, pohon. He argued that the trees that he had were between 3 centimeters and 40 centimeters tall, but really the definition of a tree required that the tree be at least 1.5 meters high. But the court looked at the dictionary definition of tree and found that a cannabis plant should be classified as a tree. So, what do I have to say about these several cases? Well, as I said at the outset, the court was very, very hard on drug offenders in these cases. It was unwilling to kind of overturn or tinker with any of the provisions that the applicants complained about. And there are various statements that the court makes about how drugs are extremely detrimental to the individuals who take them, the society of Indonesia, the nation, etc. And so the court also cites a number of, well, one, in fact, but in a number of cases, a BNN survey estimating that 5 million Indonesians are drug addicts and that 50 drug users die each day from drugs. I think that research has been kind of questioned over the years, but perhaps that's already been discussed in this conference. The court also says, well, it's not our function to get involved in concrete cases. All we can do is invalidate a law, and the invalidation would take place at the time that the decision is read out. So no one can use the court's mechanisms to actually appeal against a conviction in any case. So these applicants, I think, wanted to have their say about the narcotics law, complain about how some of the provisions operated, in fact, were interpreted, some would argue, inappropriately by law enforcement, and that was an argument certainly made in some of the cases. But the court said, well, it's actually quite futile to use the constitutional court mechanisms for that purpose. So now we get to the next slide, please. So we get to the real nub of the just my discussion tonight Australian time, but afternoon Indonesia time. We've got the first and perhaps the most important case of where medicinal cannabis was kind of the main focus. It's 106/2020, brought by a number of applicants, including ICJR, and my friend Ibu Asmin Francisca was one of the experts in the case. There were quite a few. And many of these applicants were, or the individual applicants were parents of children who had various illnesses that responded remarkably well to medicinal cannabis. So they had epilepsy and cerebral palsy, amongst other ailments, I think. And essentially they argued that really the use of category 1 narcotics, so narcotics that are classified as the most serious causing of addiction and detrimental side effects, etc. They argued that the prohibition of the use of category 1 narcotics for medicinal purposes, when they had great medicinal benefits, violated the right to health care under the Constitution, and also the right to obtain benefits from the development of science and technology, both of those being constitutional rights. Now, again, like in the other cases that I've mentioned, the court noted the drugs were dangerous. There were quite significant criminal networks involved in it, complex argument across very effectively. Now, the court was worried about what might happen if medicinal cannabis was legalized and it got into the wrong hands. They were worried about misuse of cannabis that might be designed for medicinal purposes. But the court says, well, there's a lot of risk involved in this. The court even said it was a threat to national cohesion. Now, the court says, that said, lots of other countries have legalized marijuana for therapeutic use. They've chosen their own ways to regulate medicinal cannabis. But for Indonesia at this point, any therapeutic benefits of Category 1 drugs were outweighed by the potential risks. And really what the court thought the applicants were asking for was a reclassification of various drugs, which the court said was something that it didn't want to do, needed a systematic, thorough examination. It's something that only lawmakers should be able to do. But the arguments of the lawyers were clearly very persuasive, because the court said, well, despite the problems of drugs, despite all the negative effects that they can have, they clearly have some potential benefit, at least if you believe what the applicants argue. And the state does have this right to, or this obligation, I should say, to provide health services. And so the court says, well, we're not going to do anything now, but it gave a very strong suggestion to the government to conduct further studies into the use of medical marijuana. I think I read it to mean that Indonesian studies needed to be performed. So it led the court to kind of give this veiled order to lawmakers. So the last case, next slide please, is 13 of 2024, so a very recent case. Now, in this case, we had, I suppose, a testing of the Constitutional Court's mettle. So it decided that it would issue this order to lawmakers, and 4 years later we have another applicant basically arguing the same point as had happened in 2020, but using a different law. It's not possible to bring a claim or a constitutional challenge to a piece of legislation that has already been challenged on the same basis upon which it's already been challenged in a previous case. What the applicants did in this case was argued that the law that ratified an international drug convention that justified Indonesia's particularly hard stance on drugs was the problem. And so it kind of got around the fact that a review had already been issued in relation, or already been sought in that 2020 case about the medicinal use of cannabis. And that basically the court said, well, the applicant said, this law is or should be declared invalid because, again, it's unconstitutional. They argued that the ratification of this treaty violated the right to special assistance or treatment to obtain equal treatment and benefits, which is also a constitutional right. Now, again, the applicants are saying, well, the use of cannabis for medical purposes can be very effective. The state has not yet performed, 4 years later, the research that the court said should be conducted immediately. It had failed also to provide any alternative effective treatment for some of the ailments of the applicants' children, including cerebral palsy. And what was the court going to do about this failure of the government to comply? Of course, the court says, well, we acknowledge the government hasn't responded to our previous decision on this, but at this stage, we are not going to do anything in response. So the court says, yes, the government hasn't complied, and the government should comply. And so the question becomes, well, how long is the court going to stand by and watch the government refuse to comply with its decisions? There might be a point where the court says, well, enough is enough. If the government doesn't perform the study within a reasonable time, you never know. The court might remove the prohibition on medicinal use. There are cases in which the court has kind of made quite radical decisions after the government has refused to comply with previous decisions, but we'll have to wait and see. I suppose, though, it would be a very brave court that would legalise the medicinal use of marijuana, especially given the rhetoric of the government and the court itself about the dangers of drugs. Thank you.
Okay, thank you. Thank you so much for the presentation. The point highlights by Professor Simon is related to the Constitutional Court decision in terms of the drugs policy, especially related to death penalty from the drug conflict. There is a stance from the Constitutional Court to avoid themselves to rule a concrete case from the drug conflict, and also related to the Constitutional Court. It's really hard to counter the narrative of the extraordinary crime of the drugs policy. So it's really challenging to challenge the constitutional the death penalty regulation under the drugs policy. And in terms of the medical cannabis, there is no implication from the government in 4 years after the first decision to mandate the government to do the research on medical cannabis. Until now, during the process of the revision of the narcotics law, the government still did not comply with the mandate from the Constitutional Court to have the immediate research on that. And there is another case that complaining about the miscompliance from the government itself. So we can continue to the presentation, and we will have the Q&A session after all the presentation. So let's move to the second speaker. We have Lucrezia here. Lucrezia is a research officer within the death penalty research unit at the Center for Criminology within the University of Oxford, where she is currently analyzing data for the study on the involvement of drug trades among non-incarcerated individuals. She has undergraduate degree in psychology from the University of Florence, Italy, and a master in forensic psychology from John Jay College of Criminal Justice, where she used to research about wrongful conviction and false confession. So Lucrezia, the screen is yours now.
Thank you. Can you see the slide? I see somebody has shared it. Okay. I don't have control of it. Thank you, everyone. Today, as you can see from the title, I would like to talk about the work that the Death Penalty Research Unit has been doing in Indonesia since 2019. Also, apologies if you hear other noises or doing construction work right outside of my window. Can you please go to the next slide? Thank you. So I wanted to start with the public opinion studies for the simple reason that one of the justifications that governments often give for why abolition is not in the cards for them is that the public simply does not want capital punishment to be abolished. And so the Death Penalty Research Unit decided to actually test this hypothesis. And you can see here these two reports that you can find on the Death Penalty Project websites. The first one looking specifically at opinion formers. So these are people that within the community hold a weight in the sense that, these might be people from governments or, within the news world or religious leaders. And then the death penalty research unit also looked at just the simple, people in the public. So if you can please go on to the next slide. So these are the results for the opinion former study. The overall support for abolition was actually quite high, which was surprising. Over 2/3 of the interviewees said that they would actually support the abolition of capital punishment. And perhaps more interestingly, and as we're going to see confirmed in the public opinion study, they didn't think that the overall, average Indonesian citizen would go to the street and protest if the government were to choose to abolish capital punishment. And that is a really important and key factor because, it often comes up in conversation regarding abolition. Then if we compare the people that were in support of abolition and those in support of retention of capital punishment among the opinion formers, the people who were for abolition tended to know a bit more when it came to the practices of capital punishment as opposed to those who wanted the retention. But overall, both groups agreed that just political decision makers tend to be poorly informed, and that is also quite a big issue because these are the people that then go on to make the decisions that affect people's lives. And overall, deterrence was the primary rationale. However, when the interviewees were asked questions like, how would you decrease, drug trafficking or, violent crimes in Indonesia, if not with the use of capital punishment, almost no one chose the death penalty as the primary method. Instead, they chose things like, social measures, increasing employment, or just simply more effective policing, reducing corruptions amongst officials. Could you please go on to the next slide? And so these instead are the results, the mirror results from the public. Here we see a bit of a different trend initially. So 69% of people was in favor of retaining the death penalty when asked the simple question, do you support it or do you want to abolish it? However, governments are worried about people who really feel strongly about capital punishment. So when the death penalty unit asked, okay, but how strongly do you support the death penalty? Only a quarter of interviewees actually stated that they were in strong support. And furthermore, the number from the 69% initially, only a quarter of those 69% said that they would still support it, even if there was the alternative of life without parole. Another interesting fact is that only 2% of the interviewees said that they were well informed, and only 4% said that they were very concerned about capital punishment as a practice. It's simply the type of thing that doesn't appear in people's lives on a daily basis enough, or that concerns the majority of the population for people to actually care deeply about it. And so that, spells it kind of nullify the justification of the government. People simply would not revolt. Here as well, deterrence was the primary rationale. And I think the most damning fact of all, when interviewees were presented with mitigating factors, when, we just heard from Professor Simon Butt about the real life cases, when people were put in front of mitigating factors such as, like the situation surrounding the crime, gender, mental issues, then the support lowered to 8% for murder and 14% for drug trafficking. So it's a very starkly different picture if we compare it to the initial overall support that instead is more likely to be spoken about. Could you please go to the next slide? This is I'm not going to talk about this one too much, but I just wanted to show you this feasibility report because this is the starting point when it came to the deterrent field. the deterrent research that we've been doing, and we thought we could do a very quantitative study to see whether or not capital punishment was actually deterring potential drug offenders. But then we realized that the data was just not going to be able to speak to the issue of deterrence. And so if you could please go on to the next slide, or maybe the next two, because this just also shows the report. This is the new iteration and what I'm going to be focusing on today. So instead of doing a super quantitative study, we chose to do a kind of mixed method, qualitative and quantitative study. So if you can please go on to the next. So these are the research questions that we asked our interviewees in Cipinang prison in Jakarta. So first of all, who are the people that do commit drug offenses in Indonesia? Are these the same people that are portrayed in the media? Then how did it get recruited? What are their motivations? What is not just their knowledge of the law, but their perception of their personal risk of being arrested, sentenced, and imprisoned? Because, you know, the whole idea behind the deterrence theory is that people will know the law, will say, oh, I have a high chance of being imprisoned, then I'm not going to be partaking in drugs or, you know, be involved in the trade. And lastly, profiles. I just wanted to see if there were different pathways and different decisional processes depending on certain demographics. So if we can go on to the next slide, please. So when it came to the methodology, we had 57 prisoners, all convicted of drug offenses, usually serving between 8 and 12 years in prison. And we asked them questions regarding their demographics, their background and health, including drug use, circumstances when they were trying to decide whether or not to commit the drug crime. So this involves their work situation, financial situation, familial situation. Then recruitment, motivation, why they did it, how they got into it, their knowledge and perception, and then finally some procedural safeguards. So how were they treated by the hands of the police? And the interviews were conducted by our partner researchers at Atmajaya. Probably none of our research would be possible without them. And then, yeah, they were translated in English, and then I analyzed them both quantitatively and qualitatively. Next, please. So these are the results. I'm just going to go through them quite quickly. Of course, I can share the slides afterwards if people are interested. Some interesting facts is that 55% of the individuals had been unemployed when they made the decision to get involved in the drug trade. And not only that, but even the people who were employed, mostly were employed in either self-employed or were employed in sectors that tend to be quite financially unstable. On average, each person had about 3 dependents, so that speaks to the financial burden that they felt to provide for their family and loved ones. And finally, I think this is just like an interesting thing, even though most people talked about doing these types of crimes with other people, only 8% ended up being charged with an article that signifies conspiracy. Could you go to the next slide? As you can see here from the table, the most common relationship between recruiter and person being recruited was friendship. And the main theme that emerged here was the deep level of trust between the recruiter and the person being recruited. And so oftentimes the person was just maybe using drugs or hanging out with a friend, and the friend knew of their dire financial situation, or maybe knew that they wouldn't be able to afford drugs, and proposed dealing drugs, acting as a courier, as a way of supplementing their income, or as a way of affording new drugs. Next, please. And this, also ties in with the motivation. 3/4 of interviewees said that they did not have enough money. And therefore, the financial motivation was the primary reason. We see here from the table that if we don't take into consideration the ones in the darker yellow beige, then most people just did not have enough money to get by or live their life in a constant like financial up and down. So yeah, I just divided this because some people mentioned having enough and having more than enough with the drug trade. So I didn't want to conflate the two. And yeah, the thrill seeking, we did ask them, you know, did you also do it for the thrill? Did you do it because you wanted to be part of maybe this glamorous world of drugs? And only a few people said that they actually enjoyed being part of a drug cartel, or that they equated that lifestyle to something enjoyable. Could you please go on to the next one? And then finally, we have knowledge of the law. As you can see here, a good proportion of interviewees said that when they decided to go and do the drug offense, they had known the law quite a bit, or a 10% said they kind of had known the law before. And so this is important because our expectations were, well, if we find that people actually don't know that what they're doing is illegal, then the whole deterrence mechanism doesn't work. However, they knew that what they were doing was wrong and was illegal, then, you know, we need to understand, like, why did they still go through with it? But here I have a quote that I think is of interest for further discussion, saying, some friends of mine got arrested and they didn't get more than 2 years. So I thought the risk was low and tried to be brave and didn't think much of the risk. So one of the other theme is, not truly understanding what the actual consequences are going to be, and many people mentioning potential backup, not just from other people in the drug trade, but even from police officers at times, being able to bribe their way out of a conviction. Next, please. And then, yeah, risk perception. As you can see here from the table, most people thought that it was very likely that they were going to get caught. And many people mentioned that if they decided to go through with it, half of their body was already in prison, or like their left foot was already in prison. So they got in the drug trade thinking, it's very likely I'm going to end up in prison. And so this really doesn't match with the whole deterrence rationale that the government keeps pushing, saying, oh, well, if we keep capital punishment, if we keep these harsh punishments, then people are going to be deterred by it. For the simple fact that even when people think that it is very likely they're going to end up in prison, they still, you know, decide to do it. And this might be because there are other more pressing needs. It might be because of the trust that they have in their recruiter. It might be because they are hoping for backup. And so, yeah. These are the main findings. Could you please go on to the next one? So yeah, the conclusions. When it comes to the demographics, as we saw, and if you have looked at the little table that was there for half a minute, most of our interviewees were poorly educated, often unemployed, had several dependents, and often had prior convictions. They mostly committed these crimes out of financial need and were recruited by a friend with whom they'd been friends for, on average, 8-9 years. Most had known about the legislation to some extent, and they had estimated their personal risk of being arrested, sentenced, and imprisoned as high. So, yeah, as we said, some other elements, other factors might have been at play. And I didn't go into details when it comes to the profile just because of time constraints, but when comparing different subsets, it seemed mostly that people who had journeyed through the criminal justice system, who had come in contact with police before, or who had been in prison before, simply had higher levels of knowledge in regards to the legislation. Could you go on to the next? So yeah, I just wanted to finish off talking about the current research projects that we are involved in. The overall project name is called Mapping the Political Economy of Drugs and the Death Penalty in Southeast Asia, and it is divided in 3 kind of subsets of studies. The first one, if you can go on to the next slide, is the mapping project. Already there is an interactive map online. You can find it here. I put the URL in the slide. that talks about the foreign nationals present in death rows in Southeast Asia and Middle East. I have here a little screenshot so you know what to expect. But now we are hoping to broaden the scope of these maps to also include just people on death row, whether or not they are foreign nationals. And as you can probably tell, it's not that easy. Governments don't tend to be too transparent when it comes to who is on death row. So if any of you has any groundbreaking database they would like to share with us, please reach out. But yeah, this is what we're currently working on. And if you can please go on to the next slide. Then this is the project that I'm actually analyzing the data for like these days. There were 100 interviews with individuals who have been involved in the drug trade, but have not necessarily received harsh punishment, at least not recently. And we wanted to interview people in the community in order to compare it with the study, the Chipinang study, to see if there are differences in the way between people who maybe tend to not get arrested, or people who have been able to bribe their way out, or simply, you know, people who are still within the drug trade, as opposed to people who have been incarcerated. And we asked them the same questions that I mentioned in the Chipinang study. There were some slight variations just because, you know, we have hopefully implemented or like bettered the instrument through the years. And finally, if you can go on to the last slide. The final project is the big one. A study of death row inmates in Indonesia. So the interviews are underway, and the plan is to get more than 200 interviews with death row inmates in different regions to also get a feeling of just like the conditions or like the pathways of people all throughout the region. And the goal is to understand their decision making, to understand the decisional processes, the pathway into criminality, and also do the people on death row have a different journey into criminality than people who just get arrested and incarcerated? Do these people have particular vulnerabilities? Do these people have a particular profile? And so, yeah, basically, it's all geared towards responding to the question, why were they not deterred by the prospect of capital punishment? And unfortunately, we'll have to leave you with this question because we do not have a clear answer right now. But yes, I look forward to hearing what you guys think about it. And I think the questions are at the end, if I'm not mistaken. Okay, then thank you, everyone.
Thank you, Lucrezia. Yes, we leave our Q&A session after the presentation session. Thank you, Lucrezia, for the presentation. It's really interesting. 2 points that I highlight from the presentation from Lucrezia. She mentioned about the public opinion on the death penalty and related to deterrence effect, because we know that the narrative on the deterrence is being used to justification for the death penalty, especially in Indonesia. From the presentation, that we know that most public in Indonesia support the death penalty, but when it's come to the knowledge about the real knowledge about the death penalty, only 2% of the public in Indonesia have the full knowledge about the implementation of the death penalty. So it's questionable whether or not we really know about the implementation of the death penalty while we are supporting the death penalty. And what is interesting also, it's about the drugs illicit trade criminalization in Indonesia. It's interesting. There are aspects of the vulnerability, like the unemployment, of being financially unstable, of the people being criminalized with drugs illicit traffic in Indonesia, having the dependence to fulfill their economic obligation or needs, and also the majority of them, the motivation is about the financial motivation. And what is also interesting is about actually the knowledge about the law. The people criminalized, they are educated with the legal consequences or the law consequences of their act, but they ignore the risk and discounting the risk during their decision-making process. It's really interesting to research more, and we really look forward for the result of your research in Indonesia. Thank you, Lucrezia. And we move to the third speaker. We have Nuno Capas here from Portugal. Nuno Capas has been working for the Portuguese Ministry of Health Dissuasion Commission since they were created in 2001. These boards were created to apply Portugal's law passed in 2000 about the decriminalization of drug use. As such, he is a member of an interdisciplinary team that evaluates the drugs user. He has also been in charge of correspondence with the foreign delegation seeking information and research about the Portuguese model for drugs policy. We talk a lot about decriminalization in Portugal in our yesterday session, and we have Nuno here to present more about decriminalization in Portugal. You may begin your presentation, Nuno.
Okay, thank you very much, Maydina. Thank you for having me, for inviting me to participate in the conference. I do not have a PowerPoint presentation, so I will just be wrangling on for more or less 15 minutes until someone stops me. So just a little bit of historical background to start with. Portugal was actually the first country to abolish death penalty back in 1867. So we're talking about almost 160 years ago. So I would say that we're not only physically far away from Indonesia, but the legal framework is also fairly different, I would say. And which is not a good or a bad thing, it's just the way things are. This also falls a little bit in the decriminalization part, because the Portuguese legal framework has a specific figure that allows us to decriminalize the possession for usage fairly easily. That's what we did in Portugal back in 2000 and 2001. We decriminalized the possession for personal usage. We did not decriminalize drugs per se. Drugs are still illegal. Selling, producing, providing is still considered a criminal offense. What we decriminalized was the possession for personal usage. And it was a very specific measure. It came, well, there's a little bit of historical background that makes easier to understand the change that we decided to do in 2000, 2001, because a little bit after our democratic revolution in the mid-70s, 74, we had a huge influx of illicit drugs being pushed into Portugal, mostly as a doorway into Europe in trafficking routes. And so because Portugal was a very closed country before 74 and before the democratic revolution, we were not traditionally producers of any illicit substance. So the accessibility was not very common in Portugal before 74. So there was also not a big awareness in the public perception regarding the risks of using those illicit substances. So we very rapidly passed from a very naive society regarding the risks of illicit drugs to having an epidemic usage, mostly of heroin and mostly injected usage, which is commonly perceived as the most dangerous or the most risky way to use heroin. And so by the 80s and 90s, we had around 1% of our population using heroin. And so the political decision to decriminalize the possession for personal usage was basically aimed to provide a diversion scheme for those populations. So we didn't want to keep sending drug users to court because we thought they weren't able to provide a proper answer to their needs. And because the usage, the most common usage that we had back then was also injected heroin usage, there was also a lot of health issues associated with that usage. Overdose deaths, hepatitis infections, HIV transmission, and so on. So it was a very public and a very visible problem. And so the government decided to deal with it as an healthcare issue. And this is the big change that we had in Portugal back in 2000, 2001. And it's actually, I would say it's more or less like the first step for a big change was to assume that you want to deal with it as an healthcare issue. Because from then onwards, punishment is an option but it's the last resource that you're going to take in with that sort of population. And so that's what we did. We took our legal framework, different from the Indonesian one. So if anyone is looking for a quick solution to copy what we did in Portugal to Indonesia, it's not going to happen. What we did was basically just downgrade the possession from a criminal offense to an administrative offense. The Portuguese legal framework has these two figures, criminal acts, administrative acts, and the administrative acts do not imply criminal sanctions, and therefore you do not need the criminal and judicial system to be in place. Basically, you don't need a judge to decide upon those cases. So by downgrading the possession from a criminal offense to an administrative offense, we were able to remove the court system out of the equation. And because we wanted to deal with it as an healthcare issue, we decided to create a specific structure, an administrative authority under the Ministry of Health, to deal with those procedures that were not being sent to court anymore because they were not considered a criminal offense, but nevertheless it's still illegal. The substance is still apprehended from you. You still have a legal procedure to deal with, but it's an administrative offense procedure, fairly simple one, fairly fast one, and because you do not need a judge to decide upon those cases, we created these administrative authorities under the Ministry of Health specifically to do so. This is very important in terms of the follow-up of the procedures, and when we decided to decriminalize drug usage, we had a very specific goal, which was we do not want this population to go into the court system and into the judicial system. And so by creating these administrative authorities, basically what we did was we came up with a diversion scheme that works on a national level, and it's imposed by a law. It's not voluntarily, it's not regional, it's not a pilot, it's actually a national law that criminalizes drug usage, and therefore the diversion is automatically insured. Naturally, a diversion scheme, to measure the success of any diversion scheme, you need to evaluate not only the inputs, the people that are thrown in or that are diverted into that system, but also the outputs that that diversion scheme provides. Because the inputs is fairly easy, the outputs is actually what makes it succeed or not. In our case, it's not very complicated to perceive our system as being at least better than the old one, if not a resounding success, because being part of the Ministry of Health, we are naturally equipped to provide with those outputs. So basically what we do at the Dissuasion Commission, we have a technical supporting team, psychologists, social workers that work with us, and very basically, because I only have a very short amount of time, they have to help us determine if the risk associated with the usage of an illicit substance. And bearing in mind that risk assessment, we will do some sort of proposals, normally tailor-made for that specific person, regarding their residential area, their backgrounds, their personal skills and whatnot. And that allows us to actually provide answers specifically to that person. Normally, it's one of the biggest differences between the healthcare system and the judicial system. The judicial system tends to deal with everyone equally and blindly and fairly in the same way. And in the healthcare system, that doesn't happen. A medical doctor or a psychologist normally prescribe different therapeutic options according to the person and not the disease or the symptoms that that person shows. And that means that the center of our work is not the drugs, it's not the usage, it's the person. And therefore, it's fairly easy for us to assess if there's any need or if there's any resource in the network that can be applied to that person in order to improve their quality of life or the level of responsibility with they interact with illicit drugs. Decriminalizing for us, like I was saying, basically meant the diversion scheme. And as a diversion scheme, it works fairly well because it's applicable to anyone. It's one of the problems that I normally identify with diversion schemes throughout the world, is that there's a lot of criteria you need to meet to access that diversion scheme. And that normally reduces a lot the people that are able to access that diversion scheme. It's understandable, it's a way to increase the chances of success of a diversion scheme, but it's not very, I would say, fair to the general population because it's not applicable equally to everyone. That's what we did in Portugal. We came up with a law that basically ensures that. We did also some specific fine-tuning to that law to reduce the discretionary power from the police officer on the street, because that's our input. The input for our diversion scheme, it's basically a police report saying that someone was caught in the possession of an illicit substance. We need that to start the procedure. But then from then on, everything is under the Ministry of Health, so everything is more or less voluntarily, it has to be voluntarily accepted. We can do proposals for referrals, we can do proposals for treatment, but we don't do mandatory treatment and we don't do mandatory sanctioning, which in our case works fairly well. Normally, people tend to think, well, but if it's not mandatory, how does people comply with it? And the reason it's very simple. It's because we provide them with options. So their compliance, it's not 100% requested or needed, but it's a big part of our system. But then again, you have to bear in mind that we are working under the Ministry of Health in a country that abolished that penalty for almost 160 years. So it doesn't make a lot of sense to us to discuss this sort of issues. But nevertheless, it also has to, our system in Portugal works because basically it was tailor-made for our specific needs and with the tools that we have accessible. For example, our system works because we have an healthcare system that it's universal and tendentially free for all, meaning the accessibility to treatment is not something that is reduced because people have to pay for it. Our healthcare system ensures treatment accessibility to everyone. If the person relapses, they will still be able to keep on accessing that healthcare system. And this makes it easier for us when we are trying to reconnect that person with the health structure or with the social structure, because if you reduce the barriers for accessibility, naturally people will be more inclined to access those services. So is it perfect? No, it is not perfect. Decriminalizing doesn't solve drug-related issues. Decriminalizing doesn't solve all the problems associated with the usage of the illicit substance, but it does reduce a lot the stigma associated with using illicit drugs. It increases the accessibility. It brings a lot of the problems, of the back problems that the person has up front. People are normally fairly open about their needs and their problems regarding not only the usage of an illicit drug, but also some other social issues that together with that usage might snowballing into a larger problem. And therefore, it's also easier for us to make suggestions and eventually to do some sort of follow-ups with those people, because not being portrayed as a coercive structure like courts are, like a disconnective structure like courts tendentially are, it's much easier for people to actually go along with our suggestions because they understand they are not doing it because it's mandatory or because they did something wrong. They are actually doing it because they might improve their quality of life if they do so, and because having a very open, informal, eye-to-eye conversation with drug users makes them feel also empowered about their chances of success and their chances of actually changing their ways. And so that's basically what we do on a daily basis. We talk with people that were caught in the possession of an illicit substance for personal usage. We do have some sanctions, a list of sanctions that we can apply to those users, because decriminalizing only means that it's not dealt as a criminal offense, it's an administrative offense. As a comparison, it's in our legal framework, being caught with any illicit drugs for personal usage, it's more or less the same as being caught driving without a seatbelt. Or, for example, riding a bus, a public bus, without a ticket. So it's illegal, you're not allowed to do it, there are consequences, but they are not criminal consequences. You don't get thrown into the criminal system and into the judicial system, you don't get to see a judge, you do not get a criminal record in the end. And when we started out with this idea of decriminalizing, that was our main goal, was to avoid applying a criminal record to drug users. Normally, or traditionally, drug users are targeted by police forces as a source of information for drug dealers. Normally, police forces are not very interested in users. They are much more interested in drug dealers, and so they use the users to get information about the dealers. The problem is that in the end, they also get thrown in, mostly as witnesses, into the criminal and judicial system. If you have a legal framework that considers the possession for personal usage as a criminal offense, those people will also be convicted criminally because they are being rounded up as witnesses against a drug dealer. And that was the specific problem that we were having in Portugal in 2000, 2001, that we wanted to solve. And that was it. That's fairly easy. And I would say it's fairly easy to do all around the world regarding the legal framework that you're working with. It's fairly easy to come up with a diversion scheme that avoids sending people to court because they were caught in the possession of illicit substance. What might not be so easy to do is the healthcare approach that we took in Portugal in 2000 and 2001. And that's because, like I said before, we have a universal care system it's one of our constitutional rights. It's the right to access health services. And so we decided to create this specific one to deal with this sort of population. And it's fairly hard to measure if it's a success or not. Or I wouldn't say it's hard to measure if it's a success, it's hard to measure how much of a success it is. Because clearly it's a success, because the purpose that we had back in 2000, 2001 was to remove this population from a disconnective system like the court systems are. Court systems are coercive structures. They were invented not to deal with the criminals' problems. They were invented to deal with the problems that the society has with criminals. And that's why normally the answer that they provide is they remove the criminal from society, solving the societal problem, but not the criminal one. And the healthcare services, it's the other way around. Normally are connective services. When you go to a medical doctor, you might end up being referred to another one, or you'll do some other things inside the same structure but they do not disconnect you from your regular life, because normally they are focused on that person's problems. And that's basically what we did in Portugal. We had the issue of the UN conventions that didn't allow us to legalize or regulate any sort of illicit substance. So we have to deal with that. And that's what we did. We maintained the possession of illicit substance as an illegal issue, but we removed the criminal apparatus that were in place to deal with it, and replacing it by an health approach. And what that basically makes, or what that basically needs first, is the assumption or the courage to assume that you are not going to solve the drug-related problems. You are not going to have a drug-free society no matter how hard you try. So the next step, if you assume that, is okay, we can't solve this problem, but we can probably manage it. And manage it means a health approach, means assuming that people will use illicit drugs, meaning that if people are using illicit drugs, you might as well go for an harm reduction approach and reduce the harm associated with that usage. Do prevention first, do harm reduction afterwards. In the meantime, do also some decriminalization or get some sort of diversion scheme and separate this population from the criminal and judicial system. I think I'm exceeding my time, didn't I?
Yep. 1 minute.
Okay.
Okay.
People will have questions eventually. Thank you.
Thank you. Thank you, Nuno Kapas, for a great presentation. Nuno highlight about the historical background of Portugal, that he emphasized that we need to take a look more deeper about the constitutional context, contextualization of what the challenges we are facing in the drugs policy, like in terms of in Portugal, it's related to the democratic revolution specific problem about the injecting drugs, and the government has committed that time in 2000 that the government decided not want to have the people who use drugs to be responded in judicial system, because in judicial system there will be criminal record, there will be only linear response. When at the time when it's come to the drug use, it can be a lot of more challenging, a lot of more issues such as the healthcare problem, social problem related to the harmful of the usage of drugs. So yeah, the government, Portuguese government, committed to respond drug use, personal drug use to the health problem. So all the administration after that responded within the healthcare system. And one thing I also emphasize, a really interesting point is, Nuno said that it's really related to the healthcare system in Portugal. Why in Portugal the criminalization works? Because in the constitutional law, in the constitution of the Portugal, mentioned about the universal healthcare. And to be more precise, that Indonesia, we also acknowledge the right to health in our constitutional law. So I think it's part of the opportunity, I guess, when it comes to decriminalization. We have the mandate to decriminalization because we also have the guarantee of healthcare in our constitution. It's our reflection to also implement this decriminalization, because we have also the mandate in our constitution. Okay, thank you, Nuno. So we now move on to the next speaker to have broader discussion again about the decriminalization. We have Niv here with us. Niv is the Executive Director of Release UK, Center of the Expertise on Drugs and Drugs Law. Niv has also co-authored a number of release policy papers, including A Quiet Revolution, Drug Decriminalization Across the Globe, The Color of Injustice, Race, Drug and Law Enforcement in England and Wales. She has also provided technical assistance to the governments on issues related to drug policy and decriminalization. Niv is Associate Member of Drugs and Alcohol Research Center in Middlesex University. She is currently on the expert reference group for the London Commission on Drugs and also a member of the Research Advisory Panel for University UK's Drug Task Force. You can begin your presentation, Niv.
Thank you so much, Medina, and thank you for the invitation to speak today. I will try to be brief because I know that we are pushed for time, so if I skip a few slides, that's why. So I want to talk, first of all, just roll back a little bit and remind ourselves of what the aim of the predominant global approach to drugs, illicit drugs, is, and how successful is that. So the predominant aim is to either eliminate or suppress the use, of supply, production of all drugs. And that's what was codified in the 1961 Single Convention, where we talked about drug dependency being an evil that needed to be combated by member states. And the way that member states have done this, the way that the international treaties have framed the approach, is to say that it's a criminal justice approach that's needed, that we must criminalize people for the use and possession, supply and production of these specific substances, remembering that not all drugs are criminalized throughout the world. And I think it's really important that we remember that drug policing and law enforcement is almost the engine of the machine of the criminal justice system. It is responsible for most police interactions on the street. It is responsible for most arrests. It's responsible for most imprisonments, incarceration rates across the world. It is responsible for the high rates of death penalty use in death penalty countries. So it's really the driver of criminal justice responses globally. And does it work? does it have that deterrent effect that Lucretia mentioned? Well, I think if we just look at the World Drug Report that is published by the UN every year, we can see that clearly it doesn't. 2003, the UNODC estimated that 296 million people had used drugs in the last year. Compare that to the beginning of the century when it was 180 million. Now, obviously, we've had increases in global population, but even when we adjust for that, that's an increase of 1.6% of the world's population consuming more drugs now than at the start of the century. Similarly, in Indonesia, and I understand that there is some question over the stats here, but the BNN have reported that there was an increase in prevalence from 1.8% of the population in 2018 to 2.4% in 2019. So clearly, it's not having that deterrent effect. And at the same time, what we're seeing is significant harms being created by drug prohibition. So harms such as 500,000 people overdosed and died in 2022. 1.8 people, sorry, 1 in 8 people living with HIV who inject drugs. 1 in 2 people who inject drugs living with hepatitis C. Over 2 million people incarcerated for drug offences, a quarter of whom are there for personal possession offences, so simply for the use of these substances. And we know that the laws are not applied equitably and that they target people who are living in poverty, people who are marginalised, racialised communities, Indigenous communities. So this is an inequitable law at its core, associated with significant human rights abuses. So at my organisation, we provide legal services to the community, so we work directly with people who use drugs. But we also advocate for reform based on the experiences of those people. And so back in 2012, we started to look at decriminalisation as a response to reduce the harms. As Nuno clearly says, it is no silver bullet, but it can reduce some of the harms that I've outlined that are associated with the criminalisation of people who use drugs. At that time, Portugal was really well evidenced, and I would argue in many people's minds, including in the media, that Portugal was seen as the only country that had ended criminal sanctions for possession of drugs. That was not the case. So the research that we undertook showed that 21 countries across the globe had either decriminalised, removed criminal sanctions for possession of all drugs or possession of cannabis, and had, in some circumstances, expanded that to other activities such as cultivation of cannabis for personal use, or in the case of Spain, social supply. And in fact, many countries had adopted decriminalisation well before Portugal had. So I've mentioned Spain. In the 1980s, Spanish Constitutional Court determined that the criminalisation of people who use drugs was contrary to the right to privacy that was protected under their constitution. And in that case, they actually expanded that protection in the constitution to beyond personal use, to include cultivation of plants for personal use and supply of drugs in the absence of financial profit. So social supply is also protected under the constitution. And in Spain, there is no punishment. It is perfectly legal for those activities to occur in the privacy, in private settings. We also wanted to challenge this idea that was very much at the forefront of politicians and policymakers' minds, that any reforms that are considered progressive would result in an increase in drug use. That seems to be the obsession of policymakers, this concern that drug use and drug supply will increase, and at the same time ignoring the harms that are currently happening with the market. The definition we applied was one of no criminal record. We included both legislative reforms, so where it had been incorporated into the law, and de facto models, so where the law retained a criminal sanction, but in practice the police did not enforce that. And the Netherlands is an example of that, who implemented de facto decriminalisation back in 1976. We also included, as I said, states where only cannabis was decriminalised, and this went back to the principle of looking at prevalence rates and changes in legal frameworks and whether those changes led to an increase, which, as I said, it does not. No country that has decriminalized has experienced increases in consumption linked to that reform. And in fact, there's really great research from the University of Kent and from Professor Alex Stevens, which outlines that position. Since 2012, we have published another report. We have also set up an interactive map on Talking Drugs, which is a website that we run that is in 7 languages, that reports on drug policy developments and harm reduction developments across the world. And since that time, since the first report now, 30 countries have adopted some form of decriminalization. And when we look at US states and Australian states, that's now 50 jurisdictions. Not all models are equal. Some models are very poor. They are hollow in their approach. I know you've had detailed conversations about thresholds. And in countries such as Russia and Mexico, the thresholds are so low that the policy itself is inoperable. So it actually results in more harm because people caught above those incredibly low thresholds face incredibly harsh sanctions, including lengthy prison sentences. So we're not saying that all models are equal, but we do on the website outline the thresholds, the punishment, who makes the decision as to whether someone falls within that decriminalized model. So I'd encourage everyone to hop onto the website and play about with it. So I just want to talk about some positive examples of decriminalization. As I've said, not all models are the same. Nuno has already beautifully outlined the experience in Portugal. So I just want to pick up on a couple of the outcomes of that policy. And this comes from academic research, probably in the first 10 to 15 years of the policy implementation, the new legal framework in Portugal. So as Nuno said, in 2001, decriminalization happened. Huge investment in public health. I just want to pick up a few of those stats. So there was a 40% decrease in injecting drug use in the first 10 years of the policy, which I think is a really powerful public health success. Also the drug-related deaths, the situation in the global north, as you know, is one where we are seeing increasing rates of drug-related deaths, of drug overdoses in the US, in Canada, in the UK, in Sweden, in many of the Scandinavian countries. This is a crisis unfolding and has been unfolding for a number of years now. And so if we compare the outcomes for Portugal to countries that continue to take a criminal justice response, we can see that in Portugal in 2020, there was 10 per million overdose deaths or drug-related deaths. We compare that to the UK, where it was 7 times higher, or to the US, which was a staggering 32 times higher. So criminalization is not deterring use, but it's creating huge amounts of harms. And it's worth noting that every country in Europe that has decriminalized drugs, so this is Portugal, Spain, Netherlands, Czech Republic, Italy, all experience much lower rates of drug-related deaths than the countries within Europe that criminalize possession and use. There was also savings to the state, and I think that's a really important piece. So this is all in the reports that we've written. But in the first 15 years, it was found that there was an 18% decrease in the social costs of drugs. Some of that will be direct savings from the criminal justice system, but some of it will be indirect savings through health systems. So better outcomes because people are accessing treatment earlier, meaning that they are there's less of a burden on the health system moving forward as problems are dealt with at an earlier stage. I want to take us to the Czech Republic. The Czech Republic's history of decrim is quite a complex one, but essentially when they came out of the Soviet Union, they decriminalized drugs. But in the 90s, in the late 90s, early 2000s, they increased the penalties, the punishment for possession of drugs. And at that time, research was undertaken to look at the impact of those increased punitive approaches. And what they found was comparing the outcomes for individuals prior to the change in the law, the this more sort of punishment approach that they were taking. They found that the penalisation of drug use did not affect availability of drugs, that in fact there was an increase in drug use when these new laws, these new punitive laws came into play, and that the social costs increase. And I think the law does not necessarily, and the law does not directly impact on a person's decision to use drugs. Most people who use drugs will not take that into consideration. And in Australia, they adopted decriminalisation back in the 1980s in some states for cannabis. It's only for cannabis. We've just had the first state in Australia adopting decriminalisation of all drugs. So that was Act in 2022. But there's really great research from Australia that looks at the outcomes for individuals who were criminalised in a state that continued to criminalise possession of cannabis against the outcomes of people who were subject to a decriminalised model in another state. And criminalisation was associated with negative outcomes across employment, relationship, and accommodation. What's interesting, I think this has been established in criminology, first contact with the criminal justice system increases likely recontact. So criminalisation drives recidivism. And if we think about cannabis being, this huge, cannabis policing being this huge driver of criminalisation, then we can see how cannabis possession offences are in fact themselves a gateway into the criminal justice system, further entrenching people. And I know Damon's going to talk about young people, and it's mainly young people that we criminalise in these models across the world. There are also good economics arguments for it. I've mentioned the Portuguese, but it's a much less intensive resource approach through decriminalisation compared to criminalisation. Nuno has mentioned the UN. It's only the 1988 Convention on Drugs that requires criminalisation of possession, but there is a caveat within that framework that allows states to depart from that requirement where it is contrary to their constitutional principles. And constitutional decisions have driven much of the examples of decriminalisation across the world. And in fact, now the position of the UN is one that supports decriminalisation. So we've seen over the last decade an increasing number of UN bodies coming forward and calling for the ending of criminal sanctions of people who use drugs in recognition of how it undermines health outcomes. And in fact, in 2019, the Chief Executive Board, which represents all 33 UN agencies, including the UNODC, have stated that it is the position of the UN that member states should decriminalise drug possession for personal use. I'm going to skip these couple of slides. I just want to end by talking about Oregon, because we are hearing that Oregon is coming up a lot in conversations with policymakers. And I think the position of folks who have really kind of kept an eye on this, and particularly folks who have worked on the Oregon legislation, so colleagues at the Drug Policy Alliance, are concerned that the position in Oregon really the decision there to recriminalize drug possession has been driven by misinformation. So Oregon decriminalized possession of all drugs back in 2020 through a ballot initiative, which is like a referendum, where local citizens voted for the end of criminal sanctions for possession. Move forward 4 years. During that time, we've had a pandemic. We have had a crisis in street homelessness, which I think is affecting every city in the world, particularly cities in global north countries. So across Europe, across North America, we are seeing increased levels of street homelessness. People who are street homeless will often use drugs because of the trauma of street homelessness itself. Being homeless is an incredibly traumatic experience. And that visibility of drug use is what has undermined decriminalization in Oregon. Decriminalization did not cause that problem, What caused that problem was a crisis in housing. And that is the issue. But decriminalisation has been blamed for it. And that is why we are seeing policymakers move back. And I think we've seen a huge disservice done to the people of Oregon and a huge amount of media misrepresentation about Portugal, which was used as an example to criticise the Oregon approach, where the Washington Post and the New York Times both published stories saying that Portugal regretted the implementation of decriminalisation. Those stories were published at the same time that Portugal added synthetic opioids to the group of substances that were decriminalised, and also removed thresholds to ensure, Nuno mentioned the problem with police discretion, to ensure anyone who was considered to be a drug user, regardless of the quantity that they had, could be diverted into the brilliant system that Nuno has described to you. So I think it's really important for us, those of us who are advocating for reform, to tackle this issue head on and to say to policymakers that there has been a false narrative that's been presented about Oregon. So that's my presentation, but thank you very much.
Thank you so much, Nif, for great presentation. Nif re-emphasize about the criminalization does not deter people from using drugs. It generates more harms. First contact with the police will likely lead to the recontact with the police, and decriminalization reduces the harm. Nif gives us many evidence that the decriminalization reduces the harmful use of drugs, such as decreasing the injecting use of drugs, fall in the drug-related death. Decriminalization also improved the relation between the community and the police. And Nif also remind us in implementing the decriminalization that the narrative of the misinformation related to the decriminalization, especially in Oregon, when it's come to the pandemic situation, crisis situation with homelessness, there is huge impact to the misconception, misinformation regarding the stigma about the decriminalization. So we need to also be aware about this false narrative about surrounding the decriminalization that impacted the implementation of decriminalization. And I want to remind you in audience attendance in Atmajaya University that we will have the Q&A session. You can ask your question directly to the venue, and if you have the question in online for the participant in Zoom, you can also type the question. And now we move on to the last speaker, but not least, we have Damon here. Damon is senior lecturer in human rights, focusing on the primarily on health and human rights lectures. Prior to moving into academia, Damon worked in international NGOs as an advocate and senior manager, where he worked mostly on drug use, HIV, and global health governance. He has worked on the development of international guidelines on human rights and drugs policy. His recent publication is Towards Drugs Policy Justice, Harm Reduction, Human Rights, and Changing Drugs Policy Context. Damon will present us with on the child rights and also drugs policy. The screen is yours now.
Thank you. Thanks for using a picture there that's like 12 years old. It's very flattering. The other thing is it's a beautiful sunny day here in Sweden today. So I decided to look up what the weather's like in Indonesia, in Jakarta, and it just says excessive heat. So I hope you're enjoying that. And staying cool. Yeah, thanks for the invitation. I was at Atmajaya in 2010 talking about the death penalty for drug offenses, and although I'm sitting here in my own house, it's nice to be back in some kind of way. My original email to the organizers presented 3 ideas, and in the end I decided to combine them. So one of them was a research agenda for human rights in drug policy. The other one was child rights in drug policy, and the last one was about my own research on injecting drug use among legal minors, or those under the age of 18. And so what I'm going to do is look at maybe a research agenda for child rights in drug policy. Given that this is your first conference, I thought I'd try and provide some food for thought for the future. And along the way, I'll try and use my current work as an example, and maybe reflect on something some of the other speakers said, because there's a lot of crossovers. The first thing I want to address is why we should have a research agenda on child rights in drug policy at all. I think there's actually a lot to discuss there, but for the sake of argument and time, here's why I think we should have such a thing. I think I'm coming from two perspectives. One of them is normative, and the other one's more empirical. The normative point is just something we need to agree on or not, which is that we think that child rights are of fundamental importance, and that we expect states to live up to their child rights commitments in drug policy, or as I would say, as they pursue what I would call ordinary policy objectives. And I would distinguish ordinary policy objectives from what I would consider to be higher order human rights obligations. That can be controversial, maybe we can discuss it. The second point there is more of an observation, which is that instead of tackling the critical and difficult child rights issues that are raised by drug policy, children tend to be used as justification for whatever states are doing anyway. So the drug conventions from the UN have come up, and the 88 convention that Niamh mentioned is framed around the danger of incalculable gravity to children posed by the drug trade, and that's in the preamble. So what it's doing is using children as justification for the, in many cases, problematic provisions that follow. We see this nationally. Your own politicians do this. Announcing the 2009 drugs legislation in Indonesia, the then minister responsible said that that law would, quote, save our children and young generation. But of course, you guys know that law also contained some problematic provisions, including very specific problematic provisions for children and young people. So, look, we all agree that children should be protected from drugs. It's the most uncontroversial thing we can say. The issue is that when policy aims to protect children from drugs, slip into blanket justification for whatever the government wants to do. Now, if we think about Nuno mentioned the impossibility of a drug-free society, right? Well, the Swedish approach, or the Swedish argument in policy, has been that under the Convention on the Rights of the Child, children have a right to a drug-free society. So what we've done, what I'm worried about there is when an ordinary policy choice gets translated into a fundamental human rights norm, right? So that's more difficult to change. And I'm not sure that's what, I think it distorts what rights are for, which they should be a more critical perspective on government policy, not a reaffirmation of it. And some states have justified their use of the death penalty with reference to the Convention on the Rights of the Child too, and reported that to the Committee on the Rights of the Child. I should say conversely, although maybe I'll come to it, it fits better later on, that one of the first recommendations for not criminalizing children for drugs made by the Committee on the Rights of the Child was made to Indonesia back in 2004. So the Committee on the Rights of the Child has been pretty clear on decriminalizing at least children for a long time. So if we think that child rights are of fundamental importance, and if we're worried that they're not getting paid enough attention, but that children can be used as justification for problematic aspects, then I think the research agenda is about accountability for child rights in drug policy. And I've got 4 themes I want to talk about within that, and I'll keep an eye on my clock because I can see where this session was probably supposed to end right now. But so the first is I think this relates to Simon and Lucretia's, and actually all of the presentations so far, which I would call mapping the legal space. The first place I'd like to start there is who a child is. So I know this might sound pretty obvious, but a child is, according to child rights standards, anyone under the age of 18. Article 1 of the Convention on the Rights of the Child. Now, I know many 17-year-olds wouldn't like to be considered a child, or because they see it as a pejorative. And many young people under the age of 18 are not behaving in ways we stereotypically associate with childhood. But they are legally children nonetheless, and that's an important thing to raise. So often we hear terms like youth or young people, but and those are useful terms, but I think they can be problematic from a child rights perspective if they obscure the important differences when someone turns into an adult in law. So there's legal issues, and there's rights issues, duties, and there's serious ethical issues that change. And there's things that are lost when you become an adult, but also things that are gained. And those things can really matter, as I'm finding in my own research at the moment. The intersections between human rights more broadly and drug policy have come up a lot, and I think that's a big part of mapping the legal space. So we drafted the international guidelines on human rights and drug policy a while ago and launched them in 2019, and we've a dedicated section on children. These can be Googled, they're all free to use and so on. But it's very top line, it's just an entry point into mapping the legal space, because it can only be done in the context of a situation or country, as I think we've seen from Simon and Lucretia's research there. And actually Lucretia's research was really good there, because when I say mapping the legal space, I don't just mean in a purely legal doctrinal sense, because we experience the law too. There are perspectives on the law, there's biases on how it's implemented and so on. And I think Simon raised something really important. You can see those biases depending on who's the center of the case. You know, on the one hand, we can use children for justification, but the positive side of that is that children are also very sympathetic. And when they are the victims of, let's say, unfair drug laws, then things can look a little bit different. With mapping the legal space, I'm talking about the specifics of being under the age of 18, and also mapping out the intersections between child rights and drug policies in their broadest sense. Very, very big job. So the second theme I wanted to talk about is data visibility. And I'm not going to talk about common known problems in collecting data around drugs issues, because they're massive, but just to reflect a little bit on the choice of what we measure and who we count. So the first thing is that some children affected by drug policy just don't appear in our data, right? We have a lot of data based on school-based surveys, which are excellent and very useful. But there's a lot of young people children affected along the supply chain that really just don't appear. Children involved in illicit production, children who are affected by drug-related violence, they just don't pop up in our stats in the same kind of way. So it's actually that data invisibility that drew my attention to injecting among legal minors. A long time ago, we did a report in 2013. One of the co-authors was Claudia Stoichescu, who's online. And I'm still interested in it because it's a small group. It is a small group, so it doesn't tend to appear in big data statistics, big studies. But it's injecting drug use is this apex harm reduction concern, but we know very little about people who are injecting drugs when they're still legally children. What we now know from our research in Sweden is that about 30% of people begin injecting drugs before they're 18. Now, on its face, that doesn't sound unusual. There's probably similar data in Indonesia. If I look at the biobehavioral surveillance from 2019, there's definitely a proportion that begin before they're 18. But coming back to the rights question, even if it's a small group, right? From a rights perspective, we're not necessarily looking at it through a public health population lens, but each individual's rights. What do we then think about the fact that you can't access needle exchange if you're under 18 in Sweden, right? There's definitely people there. The data show it. It's not a non-existent thing, but you're not allowed to go. So the other issue I'd like to raise with data visibility is disaggregation. So we use all sorts of different age bands for all sorts of different reasons. I would like to encourage a research agenda that looks at the age of 18 as a very important legal cutoff. There's really 15 to 24 is a very important stage in life. We know that. That's fine. But it can obscure exactly those legal and ethical and practical issues that happen at that intersection between adolescence or childhood and adulthood. So, for example, if if we use our registers and our surveillance data, and as long as we have date of birth, we can disaggregate whatever way we want for age, right? So if we start looking at that, we can start comparing those who are legally children and those who are legally adults. And we did this in Swedish data. And what we find is that if you compare those with injection debut prior to 18 with those who were adults when they injected, you get considerably higher rates of hepatitis C. Now that they have a longer period of injecting, during which they're not accessing harm reduction services, but also a much higher rate of state control measures used against them, coercive measures of the state, right? These are important differences. And it relates to legal rights and duties related to how we address drug use among legal minors. So the last thing I want to talk about with data visibility is outcomes, and maybe this comes back to Nuno and Niamh's presentations. Both mentioned outcomes. I mean, one of the things is that drug laws are a deterrent. They just might deter the wrong stuff, right? So I was interviewing a young person recently, and this relates to something Niamh said at the end about contact producing more contact. And she said, look, once I got my first criminal record, I lost hope. I don't care. I can have 5 of them now. It doesn't make any difference. But what you do see is that fear of contact with criminal justice can deter access to health services and social services and so on. So there's been a lot of work looking at can we have different indicators now for drug policy. There's a new thing called the Global Drug Policy Index that's very good. And there's been a lot of work trying to develop human rights-based indicators. And the question I would have is, okay, well, what would be an appropriate set of indicators that literally indicate to us progress or backsliding in relation to child rights in drug policy? That's a huge, difficult thing. That's why I'm putting it in a research agenda and not trying to come up with an answer. But like coming back to my example, if we have people injecting under 18, right, as a harm reduction problem, and if harm reduction is a part of the right to health, as I hope we now all agree it is, what would quality harm reduction indicators look like for under 18s that somehow tells us something about the child's right to health? Okay, my third theme then is child rights in processes and mechanisms. And here it's just moving from laws on the books to laws in the institutions and structures of drug policy. So let me give an example of this, coming back to the UN system, something quite different. Let's consider the process of bringing new substances under international control, right? That's a diplomatic and technical process in Vienna. But every time a new substance comes under international control, state obligations under the Convention on the Rights of the Child are engaged. That's the way it's worded, right? The way the Convention on the Rights of the Child is worded. Now let's consider something like cat. There's many young people involved in cat production and sales in parts of Africa, right? I know there are parts of the Middle East as well. By a diplomatic decision in Vienna, something that's currently, say, seasonal farming and work on the family smallholding becomes prohibited as a worst form of child labor. It changes the legal status of the work without the conditions changing. The point being, that's a process, right? A mechanism. Well, if that mechanism engages international child rights norms, then international child rights norms should be part of the decision-making process, but it's not. And we could imagine that also with something like ketamine. If ketamine were brought under international control, what does it mean for the child's right to health with respect to pediatric medicine, in which it's very widely used? So now we can think, that's a treaty decision, but let's think about then parliamentary processes, or think about policy-making processes, or court processes, as we've already heard about. Okay, my final theme then is child rights in practice. And I know what I just talked about is a form of practice, but here I'm really thinking more about services, including those services that we advocate for and that we like. What would it mean to take a child rights-based approach to some of these services? Here, I'd like to reflect a little bit on not just specific rights, but child rights or human rights principles. So one of the most important child rights principles is the child's right to be heard or to be listened to. And it's one of the most, we're interviewing people who began injecting drugs when they were under 18 here in Sweden. And the most dominant theme in those interviews is a sense of not being listened to when they were under 18 and having no one to speak to. So there's a kind of a double or even triple silencing that goes on. You're not listened to because you're a minor and therefore you're incompetent. Or you're not listened to because you're using drugs and therefore you're incompetent. And your experiences in interacting with services and with the police and with social workers and so on produces outcomes that lead you to eventually silence yourself, right? There's no point being listened to, because no point speaking because no one's going to listen, or they're going to do something against you that's you're going to perceive as damaging. And that leads me to the question of another really important child rights principle, which is the best interests of the child. A very, very long-standing child welfare and child rights principle, but very, very vague, right? What does it mean for a child's best interest to be, quote, a primary consideration in day-to-day drugs practice? So to give it, again, a concrete example of that, we looked into exactly that in relation to needle exchange provision in Sweden. Because here, the best interest of the child is embedded in lots of law. And it's the same in the UK. It's a very common principle. What we found was that we found a clash of operating principles between low threshold harm reduction and best interests of the child. Because the reason to exclude under 18s from needle exchange was not because they were mean or because they thought there was something inherently wrong with it. It's because they wanted to protect the low threshold nature of the service. And given the nature of social service legislation, if an under 18-year-old turned up, they would have a duty to report them to social services. And that would introduce coercion into a service where it doesn't belong because of the low threshold commitment to confidentiality. So the question there that came up for us is, okay, well, that's a problem for harm reduction as well. How do we approach and engage with people who are below the legal age of majority when most of our protocols and operating principles weren't developed with them in mind? Now, I'm not saying nobody's thinking about this in the world. I'm just saying from a child rights perspective, and again, we're talking all the way up to 18 here. 17-year-olds probably don't like the phrase child, but there you go. The legal situation for those young people changes, and it can change on a dime. From one day to the next, you're legally permitted to go to services. The same day, you lose what's called here a gode man. You lose your representative in social services that's been looking after you. One day, you blow out the candles, you're all of a sudden a legal adult, right? Now, there's transition laws and the rest of it, but it's an important transition. And I think an agenda could look into that too. So, to summarize, I've got valuing child rights as a normative thing and being worried that we want accountability for child rights. I think in order to do that, we need to map out those complexities within the drugs policy space of being below the legal age of majority and how child rights map onto that. We need to make certain issues much more visible in the data because some children are just not being seen. And my suspicion is many, many children are being harmed by the drug policies that are justified by using children, right? And the last thing is embedding child rights in processes and mechanisms and being willing to ask critical questions even of those reforms and services we advocate for. So that was what I had to say. I hope that there's some food for thought, and I look forward to some questions.
Thank you so much, Damon, for a great presentation related to the child. Is there a reflection for us that the narrative of children's rights or rights of children become the justification of the problematic provision? Like you mentioned earlier about the Indonesian as well, we have the policy that require the child to report the drug use and have the stigmatization out of it. So it's become really problematic in the provision, but at the same time, the government used the justification as the reason for they implement this harsh policy to drugs policy in terms of to the impacted to the children. And Damon also mentioned about the recommendation for research agenda, for the upcoming research agenda, map the complexity surrounding children and drugs policy. It's been invisible during that time because we have the narrative of the protecting children from drugs, and it's give us to ignore the practice surrounding the drugs policy itself that involving children, not only to save children, quote unquote, to save children, but there is many complexity about the drugs policy and children. We need to embed it or involve children in the discussion about drugs, discussion about drugs policy reform, because yeah, the children also impacted to the drugs policy and involved in the implementation of drugs in our society. Thank you, Damon. Now we begin our Q&A session. We have a participant here in Zoom to already send a question in the Q&A chat. Let me check. Okay. Maybe I want to select some question because I think some of the question not only related to the one speaker, we can share and we can distribute the question to the speakers. And I would like to read the first question from the Muhammad Jailani. He asked about, I want to ask to the Lucrezia about the research on death penalty. The first one is, what are your questions so that you find a few percent who know the law and those who do not know the law? And the second one, did your research in Jakarta reveal a narcotics network? And I think the third one is related to the criminal procedure. What if someone is found guilty because the facts presented by the authority are not balanced due to the testifying or because of the dominance of arresting witness or the arresting police officer who is the witness? Oh, is this the common practice in Indonesia that in drugs policy implementation, in drug case, the one that testifying or aggravate the use of drug is the police themselves. So the police themselves testify to the court, proving the use of drugs. And the last question: how does the criminal justice system, especially law enforcement, prepare, charge, or determine someone guilty or innocent? Do you find there is a problem in Indonesia from your public opinion research and research in the death penalty? Maybe you, Lucrezia, you can respond to that.
Yeah, sure. So in regards to the first question, I would just first like to say that the interview questions were both quantitative and qualitative, but there was an overarching, just like we asked the interviewees to please like share their narratives with us. So the question regarding the knowledge was a close-ended question at first, but then we did ask follow-up questions such as, what did you think the likely punishment was going to be? Or what did you think was going to happen after you got arrested? So we were able to kind of match their close-ended yes or no, or yes, I knew the law a little bit, with their actual knowledge of the potential consequences. So if somebody said, yes, I know the law, but then they said, oh, I know I would get away with it. Or like, oh, like there is, drugs are not criminalized in Indonesia, which nobody said. But, in such a case, we would have been able to backtrack and actually change the first response because there was not an actual level of knowledge. So yeah, that is how we found out the percentage. Second, did your research in Jakarta reveal a narcotics network? I wouldn't say like an overarching narcotics network, but from the individual narratives, there appeared to be at least like a small group of people that the interviewee had been involved with. So as you probably all know, there is a certain level of anonymity. So even though the structure of the network, at least at the level of our interviewees, which ended up being mostly like low-level drug offenders, ended up being quite flat. So it would be like a friend, with whom they would get the drugs from, maybe the higher up, and then of course they knew the people they were selling to, or sometimes if they use the Tempel system, you know, with like a no contact delivery, they didn't even know who the people were. So I wouldn't say that there is, you know, necessarily like a narcotics network in Jakarta. I think it might just be like a lot of smaller networks, but of course we were not privy to any knowledge in regards to the higher ups, because of course they were not represented in our sample. So I cannot really speak to the presence perhaps of a broader, bigger network on top of the lower ends of the networks that we did find. In terms of the testifying, as Maidina was saying, Indonesia is quite particular because there is this thing about police officers being the witnesses. This is definitely a troubling factor, because of course the person who is either trying to assert their innocence, in some cases that we have also had in our sample of people saying I was just in the wrong place. They might have been visiting a friend, and the friend was the person who actually was the owner of the drugs. So yeah, that unfortunately that is something that happens, and short of reform on how trials are carried out and who is able to provide a testimony, then I don't see that, you know, I don't see a resolution for that. However, I think tying it with the last question about, you know, how law enforcement prepare the charges, something that came up a lot was just police corruption, and how if you have enough money, you can bribe an officer to reduce the amount of drugs that they found on your person, or sometimes they might just reduce them because they would rather keep them, or, you know, for a bunch of other reasons. Exactly. And so I think that in this case, a possible resolution would be to have a governmental body that is a bit of a watchdog for the police department. And we know that in other countries, there are such institutions that make sure the police are held accountable. And it seems that with the, you know, widespread corruption, it would be useful for police officers to at least know that there are consequences for testifying. And yeah, but it is also a wider economic problem regarding funding for police, and just, yeah, it's a very complex landscape. But yeah, thank you for these questions. I hope I responded to them in a good manner.
Thank you, Lucrezia. And I've seen Professor Simon. I was planning to give the mic to you. Okay.
Well, there we go. Great minds think alike. I just had a couple of comments about the criminal justice system and the involvement of the police. And I agree with everything that Lucrezia just said about the prevalence alleged of police corruption. But one of the interesting points that came out of the cases that I presented on was the Constitutional Court almost accepted one of the claims by the parties in one of the cases that the police had used the difference, possibly applicable provisions in the narcotics law as a kind of bargaining drug cases. But the question is, well, can we reform more broadly Indonesian evidence law? You know, generally, and it's also a question about whether courts apply the evidence law properly, because one witness's testimony is generally not considered to be enough under Indonesian criminal law to ground a conviction. So police will need more than just one piece of evidence. Now, I wonder whether courts are playing the gatekeeper role properly in terms of maintaining the rights of defendants under the law.
Okay, thank you so much, Professor Simon. Yeah, it's also, I want to emphasize something that regarding the problem of the criminal justice reform, as mentioned by Professor Simon, it's part of the problem in Indonesia criminal justice system because we don't have effective mechanism of judicial scrutiny. We found that there is a problem, huge problem. I present earlier in the session that in terms of drugs policy, the majority cases that the transaction, the negotiation between the rehabilitation or the conviction is conducted during the arrest period in the first 6 days. We know that in the criminal justice system in Indonesia, the current criminal justice, during the 6 days, there is no any judicial scrutiny at all. Like the police can even dismiss the case with the offer of the rehabilitation. And now with the narrative on the restorative justice that it's only transactional, there is no any, yeah, and then there is no any room, effective room how to hold this practice accountable because we don't have the judicial scrutiny mechanism. It's part of our reform as well. The drugs policy present the evidence how we can do the criminal justice reform generally in Indonesia. Maybe we can move on to the next question. It's also related to the first one, related to the practice of the criminal justice system. Okay, I think we already answered about the witness problem. The next one is related to the investment. Maybe Nuno, you can share your thoughts about this question is how much the investment on national investment on your country related to the drugs research to be compared with other issue field of issue. How is the investment in your country give the opportunity for community to conduct research on drugs in your country? Maybe you know.
Well, I don't know the specific figure of how much do we spend in research. What I do know is that in 2001, when we changed our drug policy, there was a big investment, or there was a bigger investment, not only in treatment, but also in prevention and harm reduction, and also in research, because we were changing in 2001 when we changed our drug policy. Decriminalization was just one of the measures that we took. So it was a huge plan. It was a very comprehensive plan that touched on a lot of subjects regarding the drug policy issue. And one of the things that we did that might be easier to relate to other countries, at least more than a figure, because we're talking, Portugal is a fairly small country, 10 million inhabitants. So I would say our budgets are normally smaller than Indonesian ones, just because of that, because of the sheer size of the population and the country in general. And so what I can say is that there was a big increase in the investment in everything related with drug policy, but also, but I think it's the most important part of our change in the drug policy back in 2001 was that we created an umbrella structure under the Ministry of Health to coordinate everything related with drug policy, including budgets. And that what that made was that there's a much more efficiency usage of that budget because there's a coordinating structure that includes prevention, harm reduction, treatment, dissuasion, reinsertion programs. So it's a fairly big, for Portuguese standards, structure under the Ministry of Health with coordinating powers regarding in terms of budget and not only policy, but also in the budgets allocated to conduct those policies.
Okay, thank you, Nuno. Maybe we can move to the participant in venue at Atmaja University. If there's any comments or question from the participant in Jakarta.
Is there any question? Okay, please, the committee, give
Yeah.
the microphone to wear glasses back there.
Thank you for the presentation. My name is Asvian. I'm from Indonesia. I want to. It's not really a question. It's like a comment for Nuno Capas from Portugal. Is it true? Right. About the decriminalization in Portugal. I listened to the presentation. You describe about theory about Portugal is not the decriminalization is not the main thing that Portugal does, but it's more like some kind of restrictions. But I think it's more like contradictive from a lot of like article of things that I learned and read somewhere about the success of decriminalization in Portugal, as well as you said that decriminalization doesn't solve all of the problem, but you mentioned again about decriminalization help to decrease the burden, decrease the prevalence of the user, decrease all of the problem as well. And I think I want to highlight the difference between Portugal and Indonesia when it comes to rehabilitation. You also mentioned that it is implemented under the Ministry of Health. I think it's really interesting because as I know, mungkin kalau ada yang kalau salah, yang di sini bisa benerin. As I know, the rehabilitation in Indonesia working under BNN, like the scope of work, the responsibility is not under the Ministry of Health. It's under the National Narcotics Institution, which is full punitive law affecting the process and not certainly focus on the health. Do you have anything to comment about those efforts in Indonesia? Do you have anything to share, like the best practices when it comes to rehabilitation under the Ministry of Health, and also probably re-explaining about the thing that you has mentioned earlier about decriminalization that doesn't solve the problem in Portugal as well? Yeah, thank you so much.
What it solves, it's the criminal record part, just that. It's a fairly simple change, and it's a very direct and very straightforward consequence. If we decriminalize, at least the way we did in Portugal, we remove the criminal sanctions, so there's no criminal record. So that's the only part that it's directly solved by decriminalization, at least the way we did it in Portugal. What happens is that because it's no longer considered a criminal offense, and people are not sent to the criminal and judicial system, everything else, it's made easier to achieve. It's not a straight line to get there, but at least it removes a lot of the barriers that normally the criminal and judicial system serves. As the comparison from the Portuguese system and the Indonesian system and the health approach, I would say that that's the big difference between Portugal and not only Indonesia, but most of the other countries, is that we decided to assume that it's an healthcare issue and therefore should be dealt with as an healthcare issue. I understand the point where Indonesia stands, where you have that national board regarding narcotics and everything related with narcotics. We also have that. The difference is that ours has an healthcare approach, and therefore sanctions is possible, but it's not the main goal, and we know that that's not the one that it's going to achieve the purposes that the Legislation Commission portrays. And so I wouldn't say it's an advice or anything that Indonesia should follow, but you should probably look into it. If you already have a national narcotic structure, but it's still very infused with the punitive approach and the sanction approach. And that normally what that makes in terms of the healthcare outputs or the treatment possibilities is that it's a one-way line. The criminal and the judicial system tends to treat everyone equally. So they will prescribe the treatment option equally to everyone, and that it will not achieve the same outcomes, and it will not be successful for some cases as it is to others, because if you deal with it as an healthcare issue, you will look into the symptoms, you will assess symptoms, and then you will propose some sort of therapeutic option according to those symptoms. And so the focus is clearly on the person. And so the therapeutic options that we provide to our users, it's also tailor-made, as opposed to the normal criminal and the judicial system that presents the same solution to everyone. So I think that that could be something worthwhile looking into, different therapeutical options for different people. But that comes, again, the first step is to change from the criminal mindset to the health mindset. If you do that, everything else will be much more easier and much more understandable, and things would not fall in place magically, but you will see a light in the end of the tunnel, I guess.
Okay, thank you so much. Has really important point that to change the mindset. Firstly, to change the mindset from the criminal to the health. This is part of our huge problem in Indonesia because we see the drug stigmatization is huge, and we always the narrative always use the narrative of war on drugs. We see the drugs-free society that our aims in Indonesia society. So one thing we have to notice about the stigmatization to change the criminal mindset to healthcare. Is there anyone in the venue at Atmaju University want to ask question or comments? If there's no one there. Okay.
Thank you so much for the very insightful discussion. My name is Chika from Kyoto University, and my question goes to Professor Barrett. And thank you very much for your presentation. And it is even moving to hear that you mentioned that the majority of children's experiences in those day-to-day drug policy is like their voices are not listened because they are children and they are using drugs. So my question is, I have read some papers from some scholars discussing that the limitation of the human rights aspect, because as you mentioned, if we only pursued on the human rights aspects, then there will be some counter argument from other perspectives mentioning that there should be some human rights to live in a drug-free world, especially for children. So my question is, could you elaborate more on about your opinion? So should we still pursue those human rights perspective even for the drug policy for children, or should we have more pursue more on other ideology like utilitarianism, like we measure health impacts or social impacts of towards the children because of the drug policy, or any kind of opinion you have? Thank you very much.
Question. Let's see. Have I got any? I have some opinions about that question. Maybe your library has my book about it. No, more seriously, it is a serious thing, because one of the problems with some human rights is, look, human rights have to be drafted. At least international standards have to be drafted intentionally in a broad way so that they apply across states over time and promote universality, right? So they have to be broad in their statement. So a lot of work over time and interpretive work has to be done as to what they mean. My argument around a child's right to a drug-free society is that it's not really based on anything. It's one of those rather simplistic human rights interpretations that goes from, here's what I'd like to see, and here's this right that sounds a bit like it, so I'm going to connect the dots. But I think that's where the kind of more detailed work comes in. But, it is difficult because people do argue for the child's right to a clean environment, which kind of sounds similar, right? And I happen to agree with that one. So we got some difficulties there. I agree with that. And it just is the case that you can flip a lot of human rights provisions and make counter arguments based on them. Now, do I think we should approach it in some other way? Well, yes and no. I mean, I think that's why I started with, do we hold a commitment that human rights matter? I tend to think so, and I think our constitutions reflect that too. So I think, yes, we should approach the human rights perspective, but not at the cost of all of that other kind of ethical, philosophical, economic, and epidemiological analysis we need to do. What I'd like to see is if there's a way we can join those things up. For example, if we think that punitive repression of drugs has bad health outcomes, right? If we think that, and if we think there's a human rights connection there, we can study that empirically. You know, that's something that can be made into an empirical quantitative research question and chased down. And I think that has very important human rights implications, even though you're not going in as some lawyer or activist, you're going in as, say, a social epidemiologist or something like that. So I think we need to apply all of these kinds of disciplines, which is a very kind of academic thing to say. But I personally don't have the skills to do those things. But you are right to be concerned that you can hear the human rights arguments flipped around, which is why I started with that use of child rights in that manner. People will argue there's a right to health, therefore prohibition of drugs. You know, we have to deal with those arguments head on when they come along and assess the strengths and weaknesses of them.
Okay, thank you, Damon. Now we have the last question before we enter to the closing statement. The question is given to Nif. There is a question. I want to read it for you. Okay, in Indonesia, some government representative claim that Indonesia has decriminalization with rehabilitation provision. However, in the broader law, there are still provisions that can criminalize people who use drugs. And rehabilitation is discretionary and lead to corruption and transactional. How do you think about this?
Thank you. I think this comes back to Nuno's point about what decriminalization does and what the intention of criminalization and decriminalization is and what the effect of it is. So if the predominant aim of the law is criminalization, even if there are provisions within the law that allow for diversion into rehabilitation, if people think there is a risk that they could be criminalized, if there is a narrative that sees them first and foremost as criminals, whether they have been charged, arrested, or whatever, it means that it is more difficult for them to come forward and seek support when they need it. And, you know, I think there is empirical evidence. Damon talked about how the laws deter people from seeking support when they need it. And, you know, we're seeing more and more research evidencing that. And so there's a piece of research that was recently produced in the UK that I think is a really powerful one, that interviewed students, so university students, around their drug use. And nearly 1 in 5 of university students who described being in a scary situation with drugs, so they needed emergency help, did not seek that emergency help for fear of prosecution, for fear of punishment. So that having that on the law books continues to operate in a way that deters people from getting the support that they need, whether that be an emergency intervention, say with an overdose in this situation with recreational use, or people seeking treatment for dependency issues. I also would say that when we have rehabilitation systems that are mandatory, that are based on your choice is rehabilitation or prison, that is not a choice. That is not voluntary treatment. That is a continuation of coercive control by the state and continuation of creating fear amongst people in terms of when they need support. So I think, you know, there are two kind of issues there. That is not decriminalization. Mandatory treatment is not an alternative to punishment. It is a continuation of punishment. And I think, you know, it's really important that we do build that evidence of why we get better outcomes when people are able to access the support they need when they need it.
Okay, thank you, Nif. Okay, now we enter to the closing statements session. We would like to ask our speaker from the first speaker, Simon, Professor Simon, to have the closing statement, 30 seconds.
Oh, well, thank you very much for having me talk today. It was a very interesting session indeed. I thought that my presentation was going to be a little bit too academic, too legal, too technical, but I'm really happy that almost all of the other speakers kind of picked up on some of the themes that I raised in terms of the criminal process and kind of mischaracterization of offences, but also the potential for decriminalisation in Indonesia at some stage in the future, perhaps. Thank you.
Thank you, Professor Simon. Lucrezia, please.
Yeah, okay, 30 seconds. The pressure is on. But, you know, I would like to thank all the organizers just because I think such a conference is so important, especially considering that sometimes as academics, we tend to be quite close-knit between ourselves, but it's hard to truly like talk to the wider public. And I particularly appreciated the hearing Niamh and Nuno about the like what's going on in the rest of the world and places where decriminalization has been successful, but also, you know, what could be the possible hiccups, because, you know, hoping for a more progressive future in Indonesia where, you know, drugs are not dealt with necessarily just with punishment. I think it's really important to see what else has been done. So yeah, it's been a really great experience. Thank you for having me.
Thank you, Lucrezia. And Nino?
Well, first, thanks for having me, for inviting me to the conference. And also, I would like to point out the other speakers in this panel. I really enjoyed the way we managed to intertwine all our different perspectives. And I think that's probably a good conclusion to this panel, is that regardless of the background or of the places, of the legal frameworks that we're working with, there's always connection points and there's always things that we can learn and that we can take from one another. And I think that's a good part. And I would just like to end saying that maybe Indonesia cannot do the way things that we did in Portugal, but I think the process to get there, the mixing of different perspectives and eventually coming to a conclusion, that's doable anywhere else in the world. And just let me know if I can help with anything. Thank you.
Thank you, Nuno. Niamh?
Just to reflect what others have said, thank you so much for the invitation and for being able to be part of this conversation this afternoon. I'm really taken by the work that's been going on in Indonesia amongst civil society and academia to really push for reforms. We are privileged enough at Release to host fellowships which see folks from Indonesia, some of whom are in the room. I know Matthias from the from the Indonesian Judicial Research Society is there. But like, it's just so impressive to see so many civil society actors, people who use drugs, activists, academics, working for a more progressive approach within Indonesia, one that's based on human rights. I have to say, it's you know, in the UK we struggle to have that kind of sort of joined up approach. So it's really just very inspiring. So thank you.
Thank you, Niamh. Damon?
I can't top that because we have a similar situation. It's a quite weak civil society space in Sweden too. Very top-down, government-heavy. We like bureaucracies here. It's not all bad. Some of us academics are doing our best, and there's some organizations that are very good. But I'll just conclude. In the chat on Zoom, I put a link to the International Guidelines on Human Rights in Drug Policy. Please have a look. It was a very, very big project. There's a lot. It's very extensively commented on, so there's a lot of references to what we're saying. We don't just make stuff up. We're trying to really show how human rights applies to drug policy in a broad way, and hopefully some section of that will give you food for thought. In some way, you can dig deeper into your own context. And I think the others would agree that you're free to reach out to us if you need us.
Okay, thank you so much for all the speaker. I think we can have a great session here. I also personally learned a lot about the decriminalization, death penalty, constitutional rights, and children's rights in terms of the drugs policy. Is hopefully that we can share each other's knowledge to implement our effort, our activism, or our research on the drugs policy globally and also in Indonesia. I also want to emphasize, convey our appreciation to the all the doors of the events, the organizer, the ICDR and also ICDR for holding this event, the conference. And I would like to also thank you all, the participants, both in Zoom and also in person in university, Atmajaya University that are already here, being with us in this today's conference. And we learned so much to each other about the drugs policy research and policy, and hopefully that we can continue our research agenda as mandated by Damon. Damon mentioned a lot about the recommendation of our research agenda, our upcoming research agenda. Hopefully that we can hold the second international conference on drugs and policy research 2025, I guess. And thank you a lot for this opportunity to moderate this plenary session as a closing plenary session. I'm so sorry, I apologize for any shortcoming for my end. And I'll give the floor to the Master of Ceremony or the closing statement from the chairs, ICDR, Bu Asmin. I give the floor to the Master of Ceremony. Thank you so much and have a good day, good afternoon.
Okay, thank you, Maidina. Ladies and gentlemen, next we will have the summary and recommendation session from the plenary and panel results. And this session will be hosted by Rainov Tumorang Pamintori. He is a researcher from the Lembaga Advokasi Kajian Independensi Peradilan Indonesia atau LAIP, and also a member of JRKN, Jaringan Reformasi Kebijakan Narkotika. Rainov is passionately involved in drug policy advocacy in Indonesia. I kindly request, oh ya, sudah di atas panggung. Please, the stage is yours.
Oke, ya. Selamat sore, dan saya pertama-tama mohon izin untuk menggunakan bahasa Indonesia agar cepat ya, karena nanti kalau saya pakai bahasa Inggris lama mikirnya, biasanya begitu. Oke, pertama-tama saya berterima kasih kepada panitia dan juga pihak-pihak yang telah mendukung terlaksananya kegiatan ini, karena ini kegiatan pertama terkait konferensi internasional dalam penelitian soal obat-obatan dan juga drugs policy, di mana kita dari berbagai latar belakang bisa berkumpul. Ada yang sarjana hukum, ada yang orang farmasi, ada orang kedokteran, ada pegiat HAM, ada pegiat komunitas pengguna narkotika. Semuanya ada di sini dan saling berbagi pandangan, dan mudah-mudahan ini forum-forum seperti ini bisa terus berjalan di luar International Conference ini dan juga mungkin di conference lainnya. Nah, tugas saya, Bapak Ibu dan rekan-rekan, merangkum semua sesi panel maupun plenary yang sudah terlaksana dari hari kemarin. Saya akan coba cepat, yang pasti Bapak Ibu semua sudah terlibat dalam diskusi di dalamnya. Jadi saya mungkin akan highlight poin-poin penting saja. Dan di hari pertama kita mulai dari pemaparan atau keynote speech dari Ditjen PP, Ditjen Peraturan Perundang-undangan Kemenkumham, di mana banyak menginformasikan soal revisi Undang-Undang Narkotika yang sedang berjalan prosesnya. Dan di sana kita mendengar bahwa diakui bahwa Undang-Undang Narkotika yang berlaku saat ini memang cacat, terutama dalam segi formulasinya, membingungkan bagaimana membedakan antara pelaku dan, pengedar, pengguna, dan juga layer lainnya dari perbuatan pidana narkotika. dan akhirnya menimbulkan overcrowding di lapas di mana dipenuhi oleh para pengguna narkotika. Juga ada isu-isu atau masalah dalam pelaksanaan rehabilitasi, banyak standar-standar yang berbeda digunakan oleh berbagai penyedia layanan rehabilitasi, lalu ada perkembangan zat psikoaktif baru, yang mana ini isunya adalah sangat banyak zat psikoaktif baru yang muncul, tetapi regulasi tidak bisa keep up dengan perkembangan tersebut. Nah, kita mendengar komitmen pemerintah bahwa mereka mau menempatkan fokus yang lebih kepada pendekatan kesehatan, termasuk menempatkan instrumen-instrumen baru seperti adanya rentang ambang batas penguasaan narkotika, adanya panel asesmen terpadu dan peningkatan kualitas rehabilitasi, dan juga prosedur yang lebih berhati-hati dan menyeluruh dalam penggolongan narkotika dan juga mengidentifikasi zat psikoaktif baru. Forum ini diakui sebagai suatu forum partisipasi publik, jadi semoga apa yang kita sampaikan di sini.
Kak Renov, mohon
ya.
Untuk temponya agak dipelankan
Oh,
sedikit.
oke, ya, sorry.
Terima kasih.
Dan forum ini diakui sebagai forum partisipasi publik dan diharapkan apa yang kita sampaikan di sini bisa menjadi masukan yang positif bagi penyusunan draft revisi Undang-Undang Narkotika. Next slide. Lalu kita bicara di plenary pertama, ada 2 isu besar sebetulnya yang dibahas, hukum dan regulasi serta obat-obatan, kesehatan dan juga riset. Dari segi hukum dan regulasi, kemarin ada yang bicara jaksa dan juga polisi dan juga hakim mengakui bahwa criminal justice atau sumber daya dari sistem peradilan pidana itu banyak digunakan untuk menindaklanjuti atau menindak penguasaan narkotika dalam jumlah kecil, yang mana itu bukan menjadi sebetulnya tujuan utama dari penegakan hukum ya. Dan juga hukuman mati telah gagal untuk mengatasi penanggulangan tindak pidana narkotika. Serta juga diakui bahwa pendekatan kesehatan, penguatan rehabilitasi, dan juga peningkatan kapasitas kesehatan, layanan kesehatan adalah prioritas ke depannya untuk menanggulangi masalah penggunaan narkotika. Dari segi kesehatan dan juga riset, kita kemarin mendengar pemaparan dari Kementerian Kesehatan dan juga BPOM. Sangat beruntung kita mempunyai Kementerian Kesehatan dan juga BPOM yang sudah punya banyak pengalaman berhadapan dengan atau melayani pengguna narkotika dan juga pengawasan obat dan makanan, dan sudah ada komunikasi dan koordinasi yang terjalin selama ini antara berbagai institusi. Jadi kita sudah tentu bisa manfaatkan situasi status quo ini ke depannya untuk bisa semakin diperkuat demi memperkuat pelayanan kesehatan bagi pengguna narkotika. Dan juga kemarin disampaikan bahwa riset-riset terkait obat-obatan, baik itu narkotika, psikotropika, sangat sulit dan jarang sekali ada di Indonesia. Tapi tentu itu menjadi penting, riset-riset ini akan tetap menjadi penting dan juga beneficial untuk penyusunan kebijakan publik. Jadi hal-hal ini, riset-riset ini harus tetap selalu diutamakan dan juga didorong untuk dilaksanakan. Nah, ini kemarin ada sedikit quote dari Pak Erasmus yang saya kurang tahu mengutip dari mana karena biasanya dia mengutip, bahwa perang terhadap narkotika seringkali menjadi perang terhadap pengguna narkotika, dan ini menjadi pesan besar yang menjadi refleksi kita untuk perubahan legislasi terkait narkotika. Kemudian ada 6 topik yang kita bahas dalam panel-panel berbeda. Saya hanya akan memberikan highlight besarnya saja dari setiap topik. Yang pertama terkait tantangan dari kebijakan narkotika di Asia dan di tingkat global. Kita melihat dari berbagai presenter yang sudah menyampaikan pemaparannya bahwa penggunaan narkotika atau obat-obatan untuk kepentingan kesehatan itu terus berjalan, terus terlaksana, ada perkembangan. Sebagai contoh misalnya adanya nanomedicine, tapi ternyata kemampuan atau kapasitas peraturan atau legislasi untuk keep up dengan perkembangan tersebut ternyata sangat sulit. Lalu kita bicara soal prohibitionist drug policy yang mencerminkan adanya kolonialitas dan juga di Asia itu ternyata telah melanggar hak-hak masyarakat, hak-hak penduduk untuk mendapat standar hidup yang layak. Dan juga di konteks Indonesia, kebijakan yang tidak ajak, yang juga tidak konsisten, telah menimbulkan banyak ancaman kepada pengguna narkotika, khususnya untuk mengakses rehabilitasi dan juga secara spesifik berdampak kepada perempuan, karena tidak adanya perspektif gender yang baik dalam penyusunan kebijakan narkotika. Lalu slide selanjutnya, kita juga bicara soal tidak adanya akuntabilitas dalam sistem peradilan pidana dan juga rehabilitasi menjadi fasilitas atau suatu sarana yang sulit diakses oleh pengguna narkotika dengan berbagai sebabnya, entah itu mahal, korupsi dan sebagainya. Akhirnya pemenjaraan jadi prioritas atau pilihan yang lebih disukai dalam tanda kutip. Dan terlepas dari itu semua, sebetulnya dengan segala manfaatnya narkotika, tentu kita tidak bisa memalingkan muka dari situasi perdagangan gelap narkotika yang transnasional. Dan ini tetap menjadi isu ke depannya, adanya kebutuhan untuk menguatkan negara, kapasitas negara dalam menanggulangi masalah peredaran gelap narkotika transnasional. Slide selanjutnya, dalam hal dekriminalisasi, slide selanjutnya mungkin ya. Terkait dekriminalisasi, hal yang menyenangkan adalah kita punya general pemahaman umum, kita sepakat secara umum bahwa Undang-Undang Narkotika Indonesia itu cacat dari segi formulasinya dan juga penerapannya. Dan kita juga sepakat bahwa pengguna narkotika itu tidak boleh dikirim ke penjara. Dampak dari Undang-Undang Narkotika yang cacat tersebut akhirnya menimbulkan overcrowding di penjara, ketiadaan riset yang proper soal keuntungan medis dari narkotika dan obat-obatan lainnya, dan juga inkonsistensi dalam penegakan hukum, terutama dalam kasus-kasus yang melibatkan pengguna narkotika. Sementara itu upaya dekriminalisasi itu terhambat oleh adanya stigma dan juga faktor-faktor politik pragmatis seperti yang kita sudah lihat bagaimana dijelaskan oleh Simon Butt tadi di MK upaya-upaya untuk menggunakan ganja sebagai obat-obatan itu juga terhambat karena alasan-alasan yang politis, pragmatis dan sebagainya. Sementara itu rehabilitasi dan inisiatif terkait restoratif justice itu sejauh ini masih dianggap sebagai sarana alternatif untuk mencegah pengguna narkotika masuk ke dalam lapas. Dan ini dilihat sebagai salah satu bentuk dekriminalisasi, di mana saya tempatkan tanda tanya besar di situ. Selanjutnya, revisi narkotika seharusnya menyeimbangkan antara perspektif penegakan hukum dan juga perspektif kesehatan. Serta pendekatan-pendekatan scientific base harus diutamakan dalam merevisi Undang-Undang Narkotika. Dan terkait isu harm reduction, policy making and evidence, kita bicara banyak hal soal bagaimana harm reduction itu harus dianggap sebagai dipahami sebagai sesuatu yang beragam, berdasarkan beragam ideologi dan juga interseksional. Dalam melihat harm reduction kita juga mesti melihat bahwa ada perspektif manfaat narkotika, jadi bukan hanya sifat jahat narkotika, tetapi narkotika juga punya manfaat. Selain itu penting juga melibatkan pengguna narkotika, komunitas pengguna narkotika dalam advokasi kebijakan narkotika. Selanjutnya, terkait isu public health and drugs research, kita bicara banyak hal soal riset-riset mengenai obat-obatan mengandung narkotika dan psikotropika. Kebetulan saya orang hukum, jadi banyak istilah yang saya tidak mengerti, tapi ada beberapa riset yang dipresentasikan yang menarik saat itu. ada yang terkait kratom, di mana berbicara soal manfaat analgesik dari kratom dan juga soal kanabinoid dan bicara soal potensi penggunaan kanabinoid bagi penyakit malaria. Nah, riset-riset seperti ini yang selama ini kita kesulitan melaksanakannya, diharapkan kedepannya mulai bisa berkembang dengan adanya perubahan perspektif pemerintah dalam menyusun kebijakan narkotika. Selanjutnya terkait peran akademisi terhadap legislasi narkotika dan juga reformasi kebijakan narkotika. Seperti yang saya sampaikan tadi, ada pentingnya untuk kita berbicara multisektor, interdisipliner, sarjana hukum bicara dengan sarjana farmasi, bicara dengan sarjana kedokteran, bicara dengan pegiat komunitas pengguna narkotika, semua bertukar pikiran bagaimana kita bisa memberikan masukan kepada pemerintah, kepada negara untuk memiliki kebijakan narkotika yang lebih baik ke depannya. Nah, di plenary terakhir tadi, slide berikutnya, maaf. Di plenary terakhir tadi kita, yang baru saja selesai, kita membahas banyak hal-hal yang mungkin tertinggal dari sesi-sesi panel, seperti yang pertama soal politik pragmatis dari lembaga pengadilan, MK, mungkin juga pengadilan-pengadilan tingkat pertama, banding, dan kasasi, dalam memutus kasus-kasus atau kebijakan terkait narkotika. Sebagai contoh, tadi di kasus-kasus challenge terhadap pelanggaran hak konstitusional dari penggunaan hukuman mati bagi narkotika dan juga pelarangan penggunaan ganja dalam kepentingan medis. Dan juga sebetulnya kita melihat bahwa ternyata menurut riset, pandangan-pandangan atau kebijakan-kebijakan yang diambil pemerintah selama ini ternyata tidak konsisten dengan fakta yang ada di lapangan. Pemerintah bicara soal argumentasi efek jera, sementara fakta di lapangan menurut riset, orang melakukan kejahatan narkotika atau tindak pidana narkotika karena memang kebutuhan ekonomi. Jadi kebutuhan ekonomi mengalahkan segala resiko keamanan dirinya sendiri, termasuk dia rela masuk penjara meskipun dia melakukan tindak pidana narkotika. Demi kepentingan ekonomi, demi memenuhi kebutuhan keluarga. Dan kita bicara juga soal dekriminalisasi, di mana kita belum sempat berpikir bahwa dekriminalisasi ini bukanlah kebijakan yang berdiri sendiri, tetapi banyak hal yang juga perlu diterapkan secara paralel. Misalkan sebagai contoh di Portugal, narkotika tetap menjadi hal yang ilegal, tapi ada dekriminalisasi, digantikan dengan tindakan administratif, ada skema diversi ke mekanisme kesehatan, dan juga ada penyediaan jaminan kesehatan yang luas terhadap pengguna narkotika. Nah, hal-hal ini juga yang sebetulnya kita perlu diskusikan ke depannya, bahwa kita tidak hanya melempar narasi soal dekriminalisasi, tapi kita juga memberikan opsi-opsi kebijakan yang berjalan paralel untuk memperkuat dekriminalisasi. Selanjutnya kita juga tadi diingatkan bahwa ada aspek hak atas anak yang juga belum sempat terbahas dalam kita bicara soal reformasi kebijakan narkotika. Nah, Bapak Ibu, rekan-rekan sekalian, ini hanyalah beberapa, next slide ya, ini hanyalah beberapa pertanyaan yang mungkin bisa menjadi refleksi setelah kita pulang dari sini dan didiskusikan bersama rekan-rekan di komunitas masing-masing. Seperti apakah kita sudah memahami apa itu dekriminalisasi? Apakah semua orang sudah paham apa itu dekriminalisasi dalam konteks kebijakan narkotika? Kalau dia berbagai macam model apa yang mau kita pilih? Terus apa itu harm reduction? Pengurangan dampak buruk itu bentuknya seperti apa? Apakah publik secara umum sudah memiliki pengetahuan yang cukup soal hal ini? Lalu pertanyaan lainnya, apakah revisi undang-undang narkotika di Indonesia itu cukup untuk mengatasi segala permasalahan terkait penggunaan narkotika dan juga konsumsi narkotika? Apakah intervensi bersifat hukum, perubahan legislasi itu cukup, dan apakah sebetulnya ada faktor yang lebih besar dari itu yang perlu kita address ke depannya? Lalu pertanyaan-pertanyaan lain seperti apakah kita sudah menganalisis lebih dalam soal perspektif gender dalam reformasi kebijakan narkotika? dan juga perspektif pelindungan hak atas anak dalam reformasi kebijakan narkotika. Next slide. Lalu ada pertanyaan juga soal bagaimana kita mendiskusikan berbagai alternatif intervensi kesehatan dan juga pendekatan-pendekatan harm reduction dan juga dampaknya terhadap penggunaan narkotika selain soal rehabilitasi. Apakah publik secara umum sudah memahami soal itu? Bagaimana mereka menerima ide-ide soal itu ke depannya? Lalu apakah kita juga sudah membahas dengan komprehensif dan juga secara jujur mengenai stigma terhadap pengguna narkotika? Apa yang perlu kita lakukan lebih jauh untuk menghapus stigma jahatnya atau imoralnya penggunaan narkotika atau konsumsi narkotika? Dan mungkin pertanyaan paling ultimate-nya adalah apakah kita siap hidup bersama dengan narkotika dan psikotropika secara damai, tidak menganggap narkotika dan psikotropika sebagai sesuatu yang mengancam dan juga jahat, purely evil. Nah, ada beberapa rekomendasi yang saya sampaikan hasil dari melihat berbagai pemaparan dan juga mendengar presentasi dari para presenter yang luar biasa. Yang pertama, terkait rekomendasi terhadap pemerintah dan juga parlemen, ada beberapa poin yang saya highlight cukup banyak, tapi poin-poin pentingnya adalah pemerintah perlu untuk meninggalkan pendekatan prohibisionis atau pelarangan total terhadap narkotika dan juga harus mengalihkan sumber dayanya lebih banyak kepada pendekatan kesehatan dan juga praktik-praktik harm reduction untuk mengatasi konsumsi atau penggunaan narkotika. Dan juga pemerintah harus lebih melibatkan dan mendengarkan berbagai stakeholders. Dalam hal ini saya menekankan kepada akademisi, generasi muda dan juga komunitas pengguna narkotika dalam menyusun revisi undang-undang narkotika dan juga peraturan-peraturan yang relevan. Dan kemudian negara juga perlu, pemerintah perlu untuk mempromosikan penggunaan bukti-bukti ilmiah dan juga menghapus hambatan-hambatan dalam melaksanakan penelitian-penelitian terkait obat-obatan mengandung narkotika dan psikotropika dan topik-topik studi terkait hal-hal tersebut. Dan ini mungkin salah satu hal yang penting juga, pemerintah harus mengupayakan penghapusan stigma terhadap pengguna narkotika. Sebagai contoh yang paling simpel saja, bagaimana kalau kita tidak perlu lagi menggunakan terminologi pecandu narkotika ke depannya atau penyalahguna narkotika ke depannya karena timbulnya stigma-stigma yang muncul dari istilah-istilah tersebut. Lalu ada beberapa rekomendasi juga untuk akademisi dan juga peneliti. Tentunya kita harus tetap mengeksplor kesempatan-kesempatan untuk melakukan penelitian yang mungkin di sini terhambat, tapi mungkin kalau kita menggunakan resource di luar negeri gitu, itu bisa dilakukan. Nah, itu kesempatan-kesempatan tersebut harus tetap dieksplor dan juga membangun komunikasi dengan civil society, dengan masyarakat sipil, terutama juga komunitas pengguna narkotika untuk terus memperkuat pengaruh dalam advokasi terhadap perubahan kebijakan narkotika. Dan selanjutnya, rekomendasi untuk civil society organizations, kita harus tetap juga engage dengan akademisi dan peneliti, lalu mengeksplor beragam macam upaya kampanye dalam rangka mengedukasi publik terkait isu-isu relevan terkait narkotika, dan juga memberikan ruang lebih banyak bagi generasi muda dan juga perempuan pengguna narkotika untuk menyampaikan aspirasinya dalam perubahan kebijakan narkotika. Nah, sebetulnya pesan paling pentingnya dan rekomendasi paling pentingnya juga kepada donor, tapi saya nggak tahu apakah masih ada di sini. Saya sampaikan saja, yang pasti donor agencies jadi target rekomendasi juga ke depannya, harus tetap berkomunikasi dan engage dengan masyarakat sipil dan juga meningkatkan dukungan terhadap upaya-upaya multisektor dalam mereformasi kebijakan narkotika. Nah, yang ini bukan dari Erasmus, tapi saya coba bikin sendiri. Sounds lame, tapi Semoga war on drugs no more, a more human drugs policy forever. Terima kasih. Dan ini rekomendasi buat panitia. Bagaimana kalau kita lakukan lagi hal-hal seperti ini tahun depan, kalau bisa, kalau ada duitnya juga mungkin, jadi terserah, saya nggak maksa. Tapi forum ini sangat bermanfaat dan sangat menyenangkan. Semoga Bapak Ibu dan rekan-rekan merasakan hal yang sama. Terima kasih.
Baik, thank you very much. Ladies and gentlemen, we have reviewed all the submitted abstracts and posters, with the abstracts evaluated by our prominent moderators and the posters by the audience. Now, we are excited to announce the best oral presenter and the best posters. Without further ado, here are the winners. For the best oral presenter, with the title Reimagining Harm Reduction Through its Genealogy in Indonesia, congratulations Chika Yamada from Kyoto University, Japan. The winner of the best oral presenter will receive a prize of 3 million rupiah. Once again, give a big round of applause. Okay, please come up to the stage also. Oh, mau di sini aja? Oh ya, yeah. Yeah, to the front here. Yes. Oh yeah. Yes. For the documentation team, yeah, please. Yeah, arrange the position of, yeah. Mau foto di mana? Di sana atau di sini? Oh yeah. Yeah, no. Now for the best poster, yes, with the title, agak panjang, Medicinal Gold Mine or Illicit Trade, Mitigating Drug Abuse Risk in Indonesia's Biodiversity Through Regulation and Drug Development, a literature review. Congratulations, Michael Yunita from Atmajaya Catholic University of Indonesia. Please come in front, yeah. The winner of the best poster also will receive a prize of total amount 2 million rupiah. Yeay, takbiran. Okay, the recommendation team, please, to take the photo. Okay, ladies and gentlemen, we are now moving to the closing remarks, the final session of the first International Conference on Drug Research and Policy 2024. Here with us, the Executive Director of the Institute for Criminal Justice Reform, Erasmus Napitupulu, to deliver the closing remarks. Pak Eras, the stage is yours.
Baik, terima kasih banyak Ibu MC. Baik, Bapak Ibu sekalian, rekan-rekan yang terhormat, saya akan menyampaikan closing remarks yang pada intinya adalah ucapan terima kasih kepada Universitas Unika Atmajaya yang sudah mau menjadi tuan rumah kita pada First International Conference on Drugs Research and Policy. Dan yang kedua, saya ingin mengucapkan terima kasih kepada donor kami, mitra donor kami, yaitu Australia Indonesia Partnership for Justice 2 atau IPJ 2 dan The Asia Foundation. Secara langsung juga saya ingin mengucapkan kepada mitra kami, ICDR, The Indonesian Center for Drugs Research, yang hari ini berulang tahun 1 hari dengan mandornya Ibu Dr. Yur Aswin Francisca SRLM dan Dr. Eko Adi Prasetyanto. Bapak Ibu, kami juga ingin mengucapkan kepada para partisipan, para pembicara dalam 2 hari ini. Kita memiliki 2 plenary session dan 9 panel sessions. Ada 53 speakers yang hadir dalam 2 hari ini. Tepuk tangan untuk kita semua. Ada 53 abstrak yang disubmit, 51 abstrak diantaranya diterima dan dikurasi oleh para tim dari The Indonesian Center for Drugs Research. Ada Mbak Preti, ada Profesor NAD, ada Pak Siraj, ada Mas Michael, Yunita, dan Shirley Nataya. Ini tidak ada kolusi ya yang menang poster ya, karena kita tidak tahu siapa yang menang poster dari awal. Dan kalau saya pribadi sebenarnya saya suka posternya Michael dan Yunita, karena di sana ada menunjukkan substance lain yang bisa kita gunakan untuk mabok kalau kata Bang Acil. Ada kecubung dan buah pala. Jadi kita tahu Belanda ternyata kenapa Belanda sekarang meregulasi narkoba di negaranya, karena ketika Belanda datang ke Indonesia ketemunya buah pala, nutmeg yang ternyata punya psikoaktif. Jadi begitu sekarang Belanda meregulasi dengan baik, kita tahu alasannya ternyata ada kontribusi Indonesia. Saya juga ingin kami juga ingin menyampaikan bahwa dalam 2 hari ini terdaftar ada 325 orang peserta offline yang mengikuti seluruh plenary, ada 476 orang yang mengikuti secara online. Tepuk tangan untuk kita semua. Dan kami menilai, Bapak Ibu, saya ingin bercerita sedikit kenapa The First International Conference on Drugs Research and Policy ini, dan kami berharap ini bukan jadi yang terakhir. Ini kami lakukan. Alasannya sederhana, Bapak Ibu. Ini sebenarnya sudah kami sampaikan pada saat plenary kemarin, bahwa narkotika merupakan salah satu kejahatan terbesar di Indonesia. Jumlah kasus narkotika adalah yang terbesar di Indonesia. Kasus narkotika hanya kalah dengan kasus tilang, Bapak Ibu. Ya. Jadi ini adalah tindak pidana terbesar di Indonesia yang memakan sumber daya begitu besar di Indonesia, yang memakan resource yang begitu besar terhadap aparat penegak hukum kita. 70% kasus di dalam lapas rutan kita adalah kasus narkotika, related drugs. Baik, ternyata yang ini tidak nyambung ke interpreter ya. Saya akan mengulangi lagi dari awal. Oh enggak. Bercanda ya, bercanda. Jadi narkotika merupakan kasus terbesar di Indonesia. Namun begitu dalam sisi riset, narkotika di Indonesia ternyata sangat minim. Kita menyumbang sedikit sekali riset di seluruh dunia, padahal Indonesia dikenal memiliki beberapa jenis narkotika yang itu merupakan narkotika, ya kalau bisa dibilang ya, tanaman asli Indonesia, ganja, kratom, kecubung mungkin ya, dari hasil risetnya Michael dan Yunita, dan banyak sekali tanaman-tanaman asli Indonesia yang dianggap sebagai narkotika yang kemudian perlu kita manfaatkan ke depannya. Untuk itu konferensi ini hadir untuk mengetuk pintu para pembentuk kebijakan, untuk mengetuk pintu para akademisi, untuk mengetuk pintu para civil society, students, mahasiswa, jurnalis, para pegiat narkotika, aparat penegak hukum, dan siapa saja yang memiliki andil dalam drugs policy atau kebijakan narkotika di Indonesia. Kemarin juga kami melakukan launching terhadap satu modul ajar bersama yang itu disusun oleh para akademisi yang kami nilai memiliki value, nilai tambah begitu ya, dalam nantinya meningkatkan kapasitas Indonesia untuk memperbaiki drugs policy kita. Di sini hadir bersama-sama kita ada Bu Milda, Dr. Milda, ada Dr. Nela Sumika Putri, ada Pak Dr. Siraj, ada Dr. Asin Francisca, dan beberapa orang lagi yang kemudian bersama-sama dengan kita. Maka pertanyaan besarnya, dari sekian masalah narkotika yang kita hadapi, dari sekian besar peluang kita memanfaatkan narkotika, kenapa harus kampus? Karena semuanya Bapak Ibu harus kembali kepada ilmu pengetahuan. Kami percaya bahwa kebijakan berbasis bukti adalah kunci untuk kita meraih Indonesia emas, adalah kunci kita meraih Indonesia yang lebih baik. Dan kami percaya bahwa kita sama-sama ingin memperbaiki Indonesia, kita sama-sama ingin memperbaiki bangsa Indonesia, dan kita sama-sama ingin menyelamatkan seluruh masyarakat Indonesia. Untuk itu harapan kami kita bisa bekerja sama lebih besar lagi. Kami berharap kita bisa bersama-sama untuk dapat mendukung kebijakan yang lebih baik terkait dengan narkotika ke depan. Dan satu nama lagi, saya lupa tadi menyebutkannya, ketua rombongan ICJR ada Girly Aneira Ginting yang hari ini jadi mandur ya. Saya kenapa harus mengucapkan, karena saya tadi diancam ya Bapak Ibu, saya nggak boleh pulang ke kantor kalau nggak nyebut nama dia. Dan tadi Mas Renov mengatakan sebagai program manager LAIP siap untuk kemudian mendukung the second International Conference on Drugs Research and Policy. Kita doakan makin banyak akademisi yang mau menjadi tuan rumah ke depannya, bekerja sama dengan Atmajaya tentunya, dan ICDR, ICGR, dan Jaringan Reformasi Kebijakan Narkotika untuk membuat acara-acara serupa untuk mendukung dan mendorong riset yang lebih baik lagi, riset yang lebih banyak lagi terkait narkotika. Itu saja dari saya. Terima kasih banyak, terima kasih, dengan hormat kami ucapkan terima kasih banyak mendukung acara ini, dan sampai berjumpa dalam konferensi-konferensi berikutnya. Wassalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua.
Okay, thank you very much for the closing remarks. Finally, ladies and gentlemen, we have now come to the conclusion of today's event. I would like to express my sincere gratitude to all the invited guests, speakers, and participants for the active engagement and participation on the first International Conference on Drugs Research and Policy 2024. The webinar materials can be accessed through the links provided by the committee in the Zoom and YouTube chat box, as well as those displayed on the screen. We apologize for any unintended offense caused by our words and action. Thank you once again, and good afternoon, everyone.